Mr. Barnes, you have a problem hearing me?
Pardon?
You have a problem hearing with me?
Yes.
Okay. All right, sir. Can you tell me your name?
Phillip Barnes.
All right, Mr. Barnes, you were arrested in 2020 CF 10394AL. There's 16 counts on the warrant. 6 of them are sexual battery on a child over the age of 12 by a person over the age of 18. 3 counts of lascivious or lewd lascivious molestation or on a child older than the age of 12, and then 7 counts of aggravated child abuse. The judge signed a warrant finding probable cause on all those counts.
No, Judge. We filed. Okay.
The judge signed a warrant finding probable cause on all the counts. The state of Florida filed an information alleging 7 counts. Find information. Three of those being aggravated child abuse on a child under the age of 12. 4 counts of lewd lascivious molestation, 1 count of lewd lascivious molestation, and then 3 counts of aggravated child abuse. So the court is going to ROR you on 3 of the sexual battery counts that have counts, I guess, 4, 5, 6.
RR.
Yep. And then RR you on 8, 9. I think that'll be 2 lewds, right? And then there are 3 counts of aggravated child abuse. So I'd RR you on counts 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. On counts 13, 14, 15, and 16. So I got that right?
Yes.
That's the correct number. So you have 7 counts left?
Yes.
All right. And state as to, he's charged with 3 light felonies or capital felonies. 4 capital felonies, I'm sorry, light felonies. Are you asking me to hold Mr. Barnes at no bond?
Yes, Your Honor. State request to be no bond and no contact with the victim, even if he is in the jail, to make sure he understands that. Or witnesses.
Mr. Thompson?
The defense will ask you not to find proof evidence of presumption great in this case, Your Honor. Reading the arrest affidavit and the allegations are very hard to read. I do understand that. However, the burden the state has to meet today, they have to show that within the 4 corners of the arrest affidavit that there's no question of my client's guilt. And I would like to point out to the court that we do have the alleged victim statement. Okay. However, we have no independent witnesses to corroborate her accounts of what happened. We have no admission from my client about admitting to any of the allegations that were put forth by the alleged victim. There's no DNA evidence to corroborate what the alleged victim stated in the arrest affidavit. This happened years ago, and the alleged victim didn't tell anyone, not even a friend at school. No schools that the alleged victim attended ever reported signs of physical abuse or sexual abuse of the alleged victim. There's no similar crimes in my client's criminal history. Okay. My client is 73 years old, and he has 1 misdemeanor. The alleged victim has alleged that she does have bruising on her thighs, which my client told his sister, which would be the grandmother, that the alleged victim ran into his arm or ran to his hand. Even in light most favorable to the state, this is a proof of child abuse, but not sexual battery or sexual molestation, Your Honor. Also, lastly, I want to point out the health of my client. My client's in assisted facility care. He's here right now. He has a coloscopy bag that's aiding him into urinating and using the bathroom. He could barely stand with his walker. He's in very frail condition. He is susceptible to COVID-19. He's probably not going to get the proper care that he needs in the Orange County Jail. And for that reason, Right now,
Mr.
there's
Thompson,
no.
I got one question for you. Other than your speculation, have you spoken to any medical staff? Do you have anybody from the jail saying that he won't be able to get proper care if he remains with us at the Orange County Jail?
No, I haven't. All I'm going on is that in the four corners arrest affidavit that he is
Right.
in the assisted facility.
I understand. I read that in the affidavit. I got one question. Is the victim here, or has anybody had contact with the victim or the grandmother?
No, Your Honor, we've not.
All right. So, Mr. Thompson, I know what the 4th DCA says about that, about whether the court needs to find proof evidence presumption great at initial appearances. The rule seems to be unworkable to me, and I decided to kind of side with the 3rd DCA's interpretation of the law, because this is a non-adversarial hearing. It's not a hearing of right like a bond hearing. So the court's going to hold Mr. Barnes no bond on counts 1 through 4 until he can have a full bond hearing in front of the circuit judge assigned to this case. I'm not going to foreclose on finding him or find proof evidence presumption great at this time. I'm going to the court's going to reserve as to that. And on counts.
Can I ask a question for clarification, Your Honor?
Yes, sir.
Are you saying that you're making a finding of proof evidence
No,
presumption great?
I'm not. I'm not making a finding of presumption great.
Per Florida law, and
Well,
even in
as I said, there's a split in the DCA. I understand what the law says. The rule seems to be unworkable because in our current setup, I'm not set up to have Arthur hearing here.
well,
Nor is this is a rule. This is a hearing of procedure, not a hearing of right, which is something the 4th DCA didn't address in their opinion. Is that initial appearance is a procedural rule. It's not a rule. Is a rule created by procedure, not by the Constitution, not by right, like a bond hearing. And the legislature intentionally wrote into our pretrial release and bond statutes that at initial appearance, that is to the discretion of the judge whether to hold a bond hearing. And it seems like nobody's really ready for that right now. So, you know.
so moving forward, are you saying that on all cases?
Not in all cases. In this particular case,
All right.
the rule seems to be unworkable, especially when you're dealing with, because they don't address situations where you're dealing with minor children or children that are susceptible in age. So the rule is unworkable because it doesn't allow for child victims, essentially. Because the court has to take due care, has certain things they need to qualify the witness, they may need a guardian ad litem, they're actually required to have a guardian ad litem appointed. There's a whole bunch of things that need to happen prior to the court allowing that victim to testify, allowing these things to go forward in a proper procedure. To me, it doesn't seem the rule just seems to be unworkable in that manner.
Okay.
So not in all cases. Like we had a case yesterday, did the same thing. So
I would withdraw my statement when we said that we're going to be holding the state to their burden today. I withdraw my argument, and you're saying that you're not finding proof of the presumption.
I'm not finding proof
Okay.
that presumption great. I'm not foreclosing on him having an Arthur hearing in front of a judge and having a full bond hearing where the victim can be heard. The judge can have all those things done prior to the hearing, so that we can have proper understanding of what release conditions are appropriate. So, and then counts 5, 6, and 7. Of course, going to set bond in the amount of no. Which one's the?
Okay, so I have
It's
count,
the information.
okay, count 7, because the other one's.
Yeah. So he's on no bond on counts 1, 2, and 3, and then count.
4 with no line.
No, it wouldn't be on that. No, on that.
Okay,
So I'm going off the information. I'm sorry.
okay,
So he's all on count 4 on there.
okay.
That's right. Look at your sheet, because then this is what easier for me to order this. I'm sorry.
Okay, and I'll just write it down.
Yeah. All right. Since they filed the information, I'll order them on the counts that you weren't. Mr. Barnes, I released you on the counts that the state did not charge you on. But as to the counts that the state did charge you on, which is counts 1, 2, 3, and we'll say 10 of the charge of the arrest warrant, I'm going to hold you on no bond. Sorry, 1, 2, and 7. I'm sorry. 1, 2, 3, and 7. It's going to be no bond. And then on counts 10, 11.
It carries over to page 2. And another count in there.
I thought that there were 3 counts of aggravated child abuse
Let me see
in the information.
because we go off of the warrant.
Yep, so this one's not gonna,
I'll
so it
take-
counts 10, 11, 12 of the warrant, which is counts 5, 6, and 7 in the information. The court's gonna set bond, the state of bonds at $5,000 apiece. Condition of your bonds, even while you're in custody, you have no contact with the victim, no contact with the victim's family. You to maintain a separate residence from the victim, well, no return to the residence where this happened, or where the grandmother lives. You are to have no contact with any child under the age of 18 until we can get you in front of the proper judge to have the proper hearing. All right, Mr. Barnes? All right, have a great day, sir.
The attorney's gonna be assigned to a case of get you in a couple of days.
Sorry, that was like, he took it like good. That's what was back there. The accounts.
That's the procedure here.
Got one. All right, then we're calling Bryce Atkins for Mr. Kevin. This is Spanish?
No, he's not. He's just.
Oh.
Y'all, should I spoke to the clerk, please?
Yes, sir. Is something else they say you needed from me?
Yeah, I don't have the PC affidavit for this client right here. I just want to know if you have a
That's the
copy.
one I had forwarded to you. You want Jay forwarded to you?
Let me see the name.
That's the Spanish case.
When it does give it to us.
Okay, thanks.
We need to look at it before.
No, that's not the one. We got, the
Isn't that
Filio.
you? Oh, what's the name on that one again?
That's his name.
This is Kosciewella, Kevin.
I'm gonna just make him a copy. I'll give it back.
No, wait. No, I know what you're talking about. No, that's not that one. That's not the Spanish case. I know what you're talking about. You don't have the PC affidavit for that one? For Kevin? Which case do you not have? Kevin or you
No,
Kevin.
DeFilo, River, Mendoza.
Oh, then,
Yes,
yes,
that was
your
one.
JA did forward that to us. She emailed it to us.
Yeah. Okay. No, it's not that.
8:45 this
Yeah,
morning.
because it wasn't part of what I got, so we had to hunt it down. That was what took the reason why we didn't start on time.
The attorney on the phone to just hit this phone button.
All right, Mr. Akins.
Yes, good morning.
Good morning. How are you?
I'm good.
All right, we're here. Sir, can you tell me your name?
Kevin Kosciewella.
Mr. Castadola, you are here in 2021 CF 460 AO on 2 counts of sexual battery with a child between the ages of 12 and 18 by a custodial or familial by a person in a custodial familial relationship. State, what
Yeah.
are you asking me to do?
The state's request, again, Coffee Kennedy Swanson on behalf of the Office of State Attorney, asking the defendant to continue to be held at no bonds. Looking at, I believe it's an 8-page warrant. There are 2 individual victims that stated that this defendant was their dance instructor, that he invited both victims at different times back to his home or apartment, where the minor victims performed oral sex on the defendant. Also, they communicated via Snapchat and text messages, sending pornographic pictures between the two. We believe based on that information, the defendant should be continued held at no bond, no contact with any victims, no contact with any children under the age of 18. Also, it looks like when this defendant got wind of potential allegations, he left and had to be arrested in South Florida and then was transported back to Orange County.
Mr. Akins?
Yes, Your Honor. As regards to the first allegation in the affidavit, it was not corroborated as to any aspect of that. There was attempted control phone call was not completed. I'm referring to the first one that starts on page, I believe it was 3 of the affidavit, which alleged the first incident at the apartment.
But is it to the Taco Bell, well, I'll say the Taco Bell incident?
Correct.
Okay.
And when it starts from that, Judge, after that, there was supposedly some exchange between messages, but in the report, this complainant indicated that deleted anything and didn't have anything to show. The one that was saved that the detective mentioned didn't mention anything as regards to any sexual contact or any admission to any sexual contact.
Can I ask Mr. Akins to kind of yell into his phone, because it is
yeah,
hard to
like
hear him?
You got the smooth voice, so you got to speak up, like we were on a loudspeaker down here, so I can barely hear you.
I apologize, Judge.
The two incidents I saw were there was one in the apartment and there was one inside the car on the way to Taco Bell. So.
Yes, Judge, and what I was saying is I was starting on page 3 of the report where they indicate the Taco Bell incident at the apartment. Nothing corroborates that. The messages that was exchanged, if you go to the next page when they're talking about the Snapchat, none of those messages were saved. The only thing that was saved was nothing that had anything to do with any act that happened or any future act. It was something in the effect that you sound like a girlfriend I wish I had, which would not, delve into anything as far as contact. As far as the second complaint, my reading of this is once this first witness went and talked to a friend and explained this is when the second allegation came about. And so I would suggest that it was, not only suggestiveness on one part, but it was nothing that came out into somebody that was independent as an outcry witness, but to suggest that satisfies the greater standard of proof of guilt presumption great, which is a greater standard of proof beyond a reasonable doubt. And that's what the state has to show in order to hold somebody over with no bond. Okay. And nothing that would suggest in this affidavit to suggest that there has not been any admissions that was made. There was at least 3 occasions from 3 different people where law enforcement attempted to do control phone calls, which was unsuccessful. There's nothing that would suggest anything forensic that was obtained from over a month ago when this supposedly had taken place. There was nothing from the video that was attempted surveillance video that would that corroborate that, or that they interviewed the adult who was my client's girlfriend at the time that corroborates seeing my client with her at the apartment. And I think her name was Brittany, who was an adult. So, Your Honor, I would suggest that we would make the argument that based upon the affidavit which presents, although be it an allegation, but it's not one that's substantiated that would go beyond the heightened standard and heightened burden of proof of guilt of presumption great, which is greater than that of beyond a reasonable doubt. And my client has no prior criminal history, and also would notate, Judge, that again, there was no surveillance video from any of the cameras at any of the apartment complex, or anything that suggests that my client was engaged in anything other than instruction in these allegations. And no text messages that was obtained from any of these persons that substantiated any of this.
Well, Mr. Higgins, do you have a copy of those messages? And I don't. Because
no, Judge,
there was something uploaded to evidence.com. It says, but I don't know exactly what it is or what it says. So,
No, Your Honor. In the affidavit, the detective indicates that they deleted them. They didn't. Nothing was preserved. The only thing that was preserved were the ones that did not contain anything.
Okay.
If you look at page 5 of the report, in the first paragraph, it says the victim said that she deleted all of her text messages with Kevin and did not save any of the messages from Snapchat. That's
I was
on
talking
page
more
5.
about going backwards. In page 4, in the middle of that paragraph, in the middle of that page, I'm talking about the pictures and messages between Kevin and the victim and Kevin were uploaded to evidence.com. Do you have any of those?
No, Your Honor, and those
Okay.
were messages that this, said she sent him. This is not anything that he sent her or anything that bad. These are supposedly images that was sent to my client, but nothing from my client is any sort of an admission. And if anything else, if they're sending my client messages that he's not soliciting, then that's not a crime as to him. If anything, it goes towards the basis of why they would point an allegation, because he's rebuffed their advancements. But on the very next page, that next paragraph, the detective writes clearly that the victim said she deleted all of her text messages with Kevin and did not save any of the messages from Snapchat. So it sounds like it's real selective of what was saved and what wasn't saved, and that goes towards the proof of guilt and presumption great.
Right.
Now, the state may have leeway and as far as probable cause enough to effectuate an arrest, but the case law was clear as to what proof of guilt presumption the grade is, and it's definitely higher than that of proof beyond a reasonable doubt.
Correct.
And that's what we have here is just simple allegations, nothing to substantiate that.
All right,
The
so
court
Mr.
can.
Akins, hold on. All right, Mr. Akins, I understand the group evidence presumption grade standard. The court's aware of the split in the BCAs on how the court should be handling these cases at initial appearances. Since this is a procedural hearing, the court doesn't think that it's necessary that the court make that finding at this time. So the court's going to reserve as to that finding of any proof of evidence presumption grade. I'm still going to hold Mr. Say your last name again? What is it?
Kosciewella.
Kosciewella. I'm going to hold him at no bond until you can get in front of the circuit judge and have your Arthur hearing and have a full fleshed out understanding. I don't have the victim here, correct?
Correct, Your Honor.
Has anybody spoken to her family or the victims or their families?
I have not, Your Honor, at this time.
So the court doesn't feel comfortable in weighing what is appropriate release at this status at this point. Ms. Kosciewella, I'm going to hold you at no bond as to these 2 counts. I'm going to order that you have no contact with any witnesses related to this case, no contact with the victims or their families, even from the jail. That you have no contact with any child under the age of 18 while this case is moving forward. Mr. Akins is a very experienced attorney. He'll get you in front of the appropriate, the judges in front of Mr.
Judge
Akins?
Wooten, it's Judge Wooten, Division 20.
And in front of Judge Wooten, for the simple fact that the law requires me to do a lot of things that I can't do from here. So in these kind of cases, which wasn't really considered when the 4th DCA wrote their opinion and kind of was on the mind of the 3rd DCA when they issued their opinion later on. And hopefully at some point this year, the Florida Supreme Court will solve this whole issue with it for us, and we won't have the problem anymore. But until then, you'll get in front of your division judge, and they'll have a full bond here. You understand? All right. Have a great day, sir. Thank you, Mr. Akins. Good to hear you.
That's your honor. Have a good morning. You too, Judge. Counsel.
Elizabeth Jimenez refused to attend, Your Honor.
All right. This is case 2021 CF 804 AO. I'm going to appoint the public defender to represent Ms. Jimenez in this case. I'm going to, you all want to waive her appearance at today's initial appearance?
Yes, we'll waive, Your Honor.
All right, I'm going to state, I found probable cause after reviewing the charging affidavit for her arrest. I'm going to state her bonds in this case. In 2020 CT 4607 AO, the court is going to revoke her bonds as to that case, or RR status to that case. She's going to set a new bond in that case in the amount of $500. All right. All right, sir, tell me your name.
Michael Edward O'Hora III.
Say your last name again.
O'Hora.
Oral. All right. So Oral, you are here in 3 matters. The first case is 2021 CF 805, 2021 CF 806, and 2020 CF 807. And 805, you've been arrested for the charge of burglary of conveyance. And 806, you've been charged with attempted burglary of conveyance. And in 807, you're arrested for attempted burglary of conveyance. All the charging affidavits are based on the same set of facts. The court's found probable cause based on those facts alleged in the charging affidavit. I'm going to say your bonds is set. We'll make a condition of your bond. You do not return to the location where this happened and have no contact with any victims or witnesses.
All right.
You're out on bond in 2020 CF 14204 AO for a charge of burglary of conveyance. The court is going to, after finding probable cause that you commit a new law offense while out on release, is going to revoke that bond and set your new bond at none.
Okay, no action on that one?
Yeah, in Ms. Humanis' case, the 2006 case she has for dwellers is just an open case. There's no action I can take on the
Okay,
case.
thank you.
All right, now we're dispatch, right?
And then on Mr. O'Rourke, sorry, you addressed both cases? Yeah.
All 3 cases.
Okay, so just stay.
I take bonds in all his cases,
Okay.
and I revoked his bond after the 2020 case.
Thank you.
And set his new bond at none. All right, we're to the interpreter, right?
Yes.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today, Your Honor.
All right. Mr. Mayor, I am here in the BRC. This is Judge Bain. I have a defendant at the podium that's going to put the headsets on here.
I'm not sure if she needs an interpreter also, Your Honor.
Mr. I have a witness in the witness booth. Can you ask her if she needs the services of the Spanish interpreter?
¿El testigo necesita intérprete de español?
Man, I can't. You got to put the microphone down because I can't hear you.
Baje un poco el micrófono, no le podemos escuchar, señora. ¿Usted necesita el intérprete?
Sí, mejor.
Yes, that would be better.
Okay.
Your Honor, quickly before we start, I don't believe that she's the listed victim in this case. The listed victim is a minor.
Yes. I don't know who she is, so I'm going to find out right now. Ma'am, can you tell me your name?
Joanna?
Joanna?
Johanna.
Joanna, what's your last name?
¿Y cuál es su apellido?
González.
González.
All right. And how do you know the defendant?
¿Cómo conoce a usted al acusado?
Un día en mi casa, por medio de un amigo, de un vecino.
I met him at my house through a friend, a neighbor.
Okay. So she's just here in support, it sounds like.
Excuse me, Your Honor?
She's just here in like support, I'm guessing. Have you spoken to her?
No, I have not spoken to her.
All right. Sir, can you tell me your name? Senor. I think Madam Interpreter is going to interpret. Sir, can you tell me your name? Ms. Figueroa, he doesn't have the headsets on.
Sorry.
I think we're gonna have to go with
On the loudspeaker.
Yeah, we want to stay on the loudspeaker, Ms. Figueroa. I apologize.
Señor, ¿nos puede decir su nombre, por favor?
Deifilio Uribe Mendoza Morales.
Virgilio Uribe.
Deifilio Uribe Mendoza Morales.
Delfilio Uribe Mendoza Morales.
All right. Mr. Mendoza, Mr. Early Mendoza-Perez, you are here in 2021 CF 826AO.
Señor Delfilio Uribe Mendoza, usted está aquí en el caso 21 CF 286AO.
You were arrested for a warrant where the judge has already found probable cause for 2 counts.
Usted fue arrestado por una orden de detención por 2 cargos.
The first count is sexual battery by a person in a familiar or custodial relationship, and the second count is lewd lascivious molestation on a person older than the age of 12 years old.
Older than 12 years?
Yes, sir.
Está aquí por 2 acusaciones. Una es por agresión sexual y otros por actos de molestación por un menor de mayor de 12 años.
State, what are you asking me to do?
We're asking the defendant to continue to be held at no bond. The victim, looking at the 4 corners of the affidavit, the 6-page affidavit, the victim disclosed that she ran away from home.
You gotta slow down for the interpreter.
La fiscal está pidiendo que continúe a quedar detenido sin fianza. La affidavit menciona que la menor se fue de la casa, del hogar,
After an incident where the defendant penetrated her anus with his penis.
Después de un incidente donde el acusado penetró la vagina de ella con el pene.
On multiple occasions, he would kiss her and grab her on the butt.
En varias ocasiones, él le daba besos, la besaba y le agarraba las nalgas.
After several incidences, 3 described in the police report, she ran away from the house where he was her stepfather.
Y ella se fue del hogar, el hogar donde él era el padrastro.
We believe the defendant on count 1 should be held at no bond.
Creemos que en la primera causa el acusado debe quedar detenido sin fianza.
No contact with the victim or witnesses, no contact with any minor children under the age of 18.
No debe tener contacto con menores, con la víctima, y no puede tener contacto con ninguno de los testigos.
Nothing else, Your Honor.
Eso es todo, su señoría.
I'm appointed public defender to represent Mr. Uramanos. Mr. Thompson, you have an argument?
Yes, Your Honor. The defense would ask the court to use its discretion in the setting of bond in this case today.
El abogado de la defensa deja la discreción del juez en cuanto a la fianza en este caso.
We do understand probable cause was found, which is a very, very low bar.
Nosotros estamos de acuerdo que si se halla que hay causa que respalden la acusación es muy baja.
Basically, all the victim has to say that there was contact and that's probable cause.
I'm sorry, counsel. The interpreter is having a very difficult time hearing you.
Basically, all the alleged victim has to say is that there was contact and that is probable cause.
Básicamente, lo único que la víctima tiene que decir es que hubo contacto y eso es unas causas probables.
I would like to briefly comment about the evidence.
Yo quisiera hacer un comentario breve en cuanto a ese evento.
All right, before you do that, Ms. Davis, does he have an immigration detainer from ICE?
He does, Your Honor.
All right. Yeah, all right, go ahead.
Okay,
Él tiene una orden de detención de ICE, correcto.
per the alleged victim statement, there was sexual contact where blood was drawn.
Aparentemente, de acuerdo al testimonio de la víctima, hubo contacto físico donde se le tomó la sangre.
This allegedly occurred back in December.
Se alega que esto ocurrió en diciembre.
No DNA evidence was recovered.
I'm sorry, counsel, could you repeat that?
No DNA evidence was recovered.
No se recuperó ninguna prueba de ADN.
No blood-stained clothing was turned into the police.
No se le entregó a la policía ninguna mancha de sangre, ninguna prueba de alguna pieza de ropa.
Other than the alleged victim statement, there's no tangible evidence linking my client to this crime.
Aparte del testimonio de la víctima, no hay pruebas que aten a mi cliente en este caso en el momento.
The alleged victim told no one about these events, not even her close friends.
La alegada víctima no le contó esto ni siquiera a sus amistades cercanas.
Most importantly, I would like to point out
Yo quisiera señalar
that when the alleged victim's mother learned about the scenario,
que cuando la madre de la alegada víctima se enteró de este escenario
and she got involved in the investigation with the police,
y se involucró con la investigación con la policía,
she expressed serious concerns about her daughter's ability to be truthful.
ella habló de su preocupación seria de que su hija pudiera ser honesta,
Which leads the defense to assume that there may be some underlying motivations for the alleged victim's accounts.
lo cual lleva a la defensa a asumir que la alegada víctima tiene otros motivos.
And lastly, no controlled phone calls were made in which my client expressed guilt.
Y también ninguna llamada controlada fue hecha para confirmar lo que se alega que mi cliente haya hecho.
The defense believes that reasonable doubt is in serious question here.
Y la defensa piensa que hay dudas razonables en este caso.
And the defense will ask for a bond in the amount of $150,000 in count one.
La fianza, por lo tanto, la defensa pide una fianza de $150,000.
Ms. Mendoza, the court's not going to what they call find the information I received as proof evidence presumption great at this time. I'm not going to make that finding at the moment. I'm still going to hold you to no bond as account one with this warrant because it's a punishable by life offense. As account two, I'm going to set your bond amount of $25,000. You have to have no contact with this victim, her mother, or any other witness in this case. You to maintain a separate residence. You are to not return to this location.
Bien, señor Mendoza, el juez en este momento no va a hacer una determinación de que las pruebas son altas. Por lo tanto, pero como el primer caso es un delito en el cual usted puede pasar vida en prisión, va a quedar detenido sin fianza. En la segunda causa, la fianza es de $25,000. Se le ordena a no tener ningún tipo de contacto con la alegada víctima, con la madre o con ninguno de los testigos y no puede regresar al lugar de los hechos.
I've appointed the public defender to represent you and the office that Mr. Thompson to your left works for. They will get you in front of the division judge so you can have a full Arthur or bond hearing at the appropriate time.
Se le está designando a la Oficina de Defensores Públicos para la cual trabaja el señor Thompson, el abogado aquí presente en el día de hoy. Él va a poder llevar este caso a la división adecuada frente al juez asignado a este caso, donde van a poder llevar a cabo una audiencia completa para determinar si se le puede dar una fianza en una fecha más adelante.
Have a great day, sir.
Eso es todo, señor.
Ms. Figueroa, I need your help with one more case.
Yes, Your Honor.
And the defendant is putting the headsets on now. I have a, before Ms. Figueroa, can you sit on the overhead for me for one moment? I have somebody in the witness booth. Ma'am, do you need the services of the Spanish interpreter?
Señora, ¿usted necesita los servicios de la intérprete de español?
Sí or no?
¿En voz alta?
Sí.
Yes.
You got to, Ms. Figueroa, we're going to have to do this over the overhead because I need, I have two witnesses here that need your help, maybe.
Not a problem.
Sir, can you tell me your name?
Señor, ¿me puede decir su nombre, por favor?
Raul Rojo.
Raul Rojo.
All right, Mr. Ronco, you are here in 2021 MM 469AO on a charge of battery, domestic violence.
Señor Rojo, usted está aquí en el caso 21 MM469AO, un caso de agresión, violencia doméstica.
I reviewed the charging affidavit in this case. I do find probable cause for your arrest.
Yo he repasado la affidavit acusatoria en este caso y hallo que hay causas que respaldan la acusación.
Ma'am, can you tell me your name?
Señora, ¿usted me puede decir su nombre, por favor?
Lisbeth Carrión.
Lisbeth Carrión.
All right, can you tell
Lisbeth
me-
Carrión.
What's your last name?
¿Cuál es su apellido?
Carrión Santana.
Carrión Santana.
All right. Can you raise your right hand and be sworn in?
Por favor, levante su mano derecha para prestar juramento.
Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Solemnemente jura o afirma que el testimonio que va a presentar aquí en esta mañana es la verdad, toda la verdad y nada más que la verdad ante Dios.
Sí.
Yes.
All right, you can put your hand down, ma'am. Can
Puede
you,
bajar su mano, señora.
can you tell me how you know this defendant?
¿Me puede decir cómo es que usted conoce al acusado?
Como por hace 6 años.
For about 6 years.
Well, how do you know him? Is he are you your husband, wife, is your boyfriend? How do you know him?
¿Cómo es que lo conoce usted? ¿Él es su esposo? ¿Es su novio? ¿Son
El papá
pareja?
de mi hija.
¿Perdón?
El papá de mi hija.
He's my daughter's father.
How old is your daughter?
¿Qué edad tiene su hija?
3 años.
3 years old.
Do you all have a parenting plan in place by a judge, a time sharing plan?
¿Ustedes tienen un plan de compartir la custodia ejecutada por un juez?
No.
No.
Do you receive child support for your 3-year-old child from this defendant?
¿Ustedes reciben manutención de parte del acusado para la niña de 3 años?
Él me ayudaba cuando quería
He used-
solamente.
He used to help me only when he wanted to.
But is there a court order telling him to pay child support at this time?
Señora, la pregunta es si hay alguna orden judicial que al momento a él le ordena pagar manutención.
No.
No.
All right, ma'am. Can you tell me, are you afraid of this defendant?
¿Me puede decir, señora, usted le tiene temor, miedo a este acusado?
Sí.
Yes.
Do you want to have contact with him?
¿Usted quiere tener contacto con él? ¿Comunicación con él?
No.
No.
Ms. Swanson, do you have any further questions?
No, Your Honor.
Ms. George, I guess.
No, Your Honor.
State, do you have any
Se ha
motions?
preguntado si hay alguna otra pregunta para la señora. No, su señoría.
State, do you have any motions?
No objection to a $500 bond, Your Honor. No contact with the victim, no weapons, no firearms, no drugs, no alcohol, maintain separate residences.
La fiscal ha pedido que no se le permita tener contacto, no tenga contacto con los testigos, no posea armas, armas mortales, armas de fuego, municiones, no consuma alcohol y que se mantenga viviendo separado.
State, do you have any injunction information? I see a final injunction was served in a 2007 DR 5772. Is this the same victim? And then there's another injunction for 2015 DR 461 AO.
I don't have the injunctions, Your Honor, so I don't know the answer to that. I can look in our system to see if we have any other cases, criminal cases related to these two individuals.
Oh, God.
El juez le ha preguntado a la fiscal si tiene alguna información en las órdenes de alejamiento de un caso 2007 DR 5572 o 2015 461. La fiscal no tiene información en cuanto a esas órdenes de alejamiento, pero puede chequear a ver si hay alguna orden de alejamiento involucrando a estos dos sujetos en este caso.
Ma'am, do you have an injunction against this defendant?
Señora, ¿usted tiene una orden de alejamiento contra el acusado?
No.
No.
I don't see any other cases, Your Honor,
All right.
in our system. Arrested or non-arrest cases.
No tengo ningún otro caso en este sistema, en nuestro sistema.
For the record, the victim is the witness that's speaking. This is the subject of the charging affidavit. She's come to court. She has a physical appearance of having a black left eye that's swollen and discolored. This defendant has 2 domestic violence filing injunctions against him, even though and 2 arrests for battery as well. He has an immigration hold from Immigration Customs Enforcement, correct?
Yes, Your Honor.
El juez está mencionando la víctima que se ha presentado aquí en el día de hoy es la persona listada como la víctima en la declaratoria. Pareciera tener un ojo morado, hinchado. Este acusado tiene 2 casos que previamente ha tenido por incumplimiento por orden de alejamiento, 2 arrestos por agresión y el acusado tiene una orden de detención de inmigración, ICE.
Your Honor, I'm seeing that injunction for 2017 DR 5772.
Yes.
The defendant is actually the protected person,
Okay.
and the victim is the person the injunction is against.
All right. And then the 2015 case?
That's a different victim.
But that's the defendant is the...
That's the defendant is
okay.
the person.
All right, I'll correct the record as he has 1 injunction, seems to be for domestic violence against another person.
Bien, el juez corrige que él tiene una orden de alejamiento, pero es contra otra persona.
The court's going to set bond amount of $5,000 with pretrial release.
El juez establece que la fianza va a ser $5,000 con las condiciones de libertad preventiva.
Sir, you to have no contact.
Señor, usted no puede tener ningún tipo de contacto.
Did you read the no contact order?
¿Usted leyó el documento de la orden de no tener contacto?
Yes.
Do you understand?
Yes.
Do you understand the order?
¿Y usted entiende lo que esa orden dice?
Yes.
All right.
Yes.
So 0 contact, no contact with his victim. You cannot return to her residence.
0 contacto con la víctima. No puede regresar al lugar donde ella vive.
You are to possess no weapons or firearms.
No puede poseer ningún tipo de armas de fuego.
Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release.
Si usted es dueño de algún arma de fuego, una vez salga de la cárcel, tiene 24 horas para entregárselas a la policía.
You are to possess no drugs or alcohol. or consume
No
any drugs
debe,
or alcohol.
no puede poseer ni usar drogas o alcohol.
If you, I'm appointed public defender to represent you. If you have a question, you can ask them.
Le voy a designar el defensor público para que le represente. Si tiene cualquier pregunta, hágaselas al abogado.
You understand my instructions?
¿Usted entiende mis instrucciones?
If for some reason you aren't released on this ICE, you are released on this ICE detainer, or you have contact with this victim, I want to hold you in jail indefinitely until your case is resolved. You understand that?
Usted entiende, señor, que si usted puede salir después que le quiten esta orden de detención de ICE, si usted en algún momento tiene comunicación con esta víctima, yo le voy a mantener detenido en la cárcel. ¿Entiende esto, señor?
All right. Have a great day, sir.
Bien, tenga buen día, señor.
Thank you, ma'am, for coming in.
Gracias, señora, por haber venido.
Your Honor, I'm sorry. On the previous defendant with the sexual battery case.
Which one? What's his name?
Uribe Mendoza.
Yes.
Did you place the immigration on record? Because I know you asked me, but did you place it
I
on
didn't
record?
place it on record, but
Oh, okay.
that's outside.
You marked it?
Yeah.
Okay, thank you.
And that's outside my my wheelhouse of things because that's a federal government thing.
Okay.
Sir, tell me your name.
Shaquille.
Sorry, Ms. Figueroa. Thank you for your help.
You're welcome, Your Honor.
will
Thank
help
you.
Some other weary judge this morning. Tell me your name, sir.
Shaquille Fisher.
All right, Mr. Fisher, you are here in 2021 CF 159. Counselor for aggravated assault with a firearm, domestic violence, tampering with a witness in a hinder communication, child abuse, and battery domestic violence. You're also out on probation of another county for a robbery, if I remember correct. The judge signing your warrants found probable cause for your arrest. That's the count one. I'm going to set your bond in the amount of $10,000. That's the count two. I'm going to stay your bond at $500. That's the count three. I'm going to set your bond at an amount of $5,000. That's the count four. Do we have a victim here? I didn't see anybody.
No, you're.
No victim. Count four, the court is going to set your bond in the amount of $1,000. Conditions of your bonds that you have no contact with this victim, you do not return to the scene or location, no weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Based on your record, you shouldn't have any firearms in your possession.
Yes, sir.
You are to not consume any drugs or alcohol without a valid prescription, or possess any drugs or alcohol without a valid prescription. You will be held no bond as you're a violent felony or felony offender, special concern, as you're a violence to probation. And you're not entitled to release until that case is resolved.
Yes, sir.
All right. Have a great day, sir.
Your Honor, did you
I appoint a public defender to represent you in all your cases.
Excuse me, sir. I had a question. I could talk to you real quick.
I was just to talk to your attorneys first, and then you can see if you want to talk to them.
Thank you, Your Honor.
All right.
Victoria Arraignment is medical, Your Honor.
All right. this is 2021 MM 498AO. Ms. Victoria Arraignment, I'm going to appoint the public defender to represent her in this case.
We'll waive, Your Honor.
You're going to waive Ms. Arraignment's appearance in this case. The court has reviewed the charging affidavit in this case and found probable cause for her arrest. The court's going to set bond in the amount of $500 or no contact with the victim, must maintain a separate residence. How old is she? 96. No weapons, no firearms. Any weapons or firearms she has needs to be turned over to law enforcement within 24 hours. You want to tell me your name?
Good morning. Iram Urrutia Ramos.
Sir, you're here in 2021 MM 493AO on the charge of domestic violence. So he doesn't qualify now for PTR? Correct?
No.
Okay, that's what I thought.
You're addressing Gonzalez, right?
Yes.
Gonzalez
behavior.
Oh, okay. Come on back up. You're Herman?
Iram Urrutia Ramos.
Urrutia Ramos. All right. In 2021 MM 493AO, the court's going to appoint a public defender to represent Mr. Gonzalez Mendez.
Oh, okay, you're
And then you all want to waive his appearance at today's arraignments? Initial appearance?
We'll waive, Your Honor.
All right, then in that case, I will, the court reviewed the charging affidavit in this case. I'll find probable cause for his arrest. I'm going to set a bond amount of $1,000. Condition of the bond, he had no contact with the victim. Oh, sorry.
The one before?
Good morning, ma'am.
Gonzalez Mendez?
Yes, ma'am. You raise your right hand to be sworn in? There you go. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, ma'am. Mr. Gonzalez Mendez decided not, because he told me your name?
Rebecca Christina Utria?
All right, Miss, you say your last name?
Utria, U-T-R-I-A.
All right.
Similar last name to the next defendant.
Yeah,
but-
that's also, was Mr. Gonzalez Mendez decided not to join us this morning.
Can I speak?
Yeah,
I was on the phone with
I'm trying to tell you
him.
what's going on. He decided not to come to court this morning.
No, I was on the phone with him when they called him for court paperwork.
Yeah.
And he was running to the door, but the lady said he missed it. He did not refuse to come to court, so I was on the phone with him. It was like 5-something this morning.
All right. I want to tell you this. He shouldn't have been calling you from the jail.
Well, I don't have any fear of him. I need him home with me, please. This was the biggest mistake I've ever made in my whole life. That is the only man that loves me unconditionally and will be there for me no matter what.
All right. So I got a question for you. Are the allegations or any... State, do you have any questions for this victim?
Has anything like this happened in the past?
Previously.
I'm sorry?
Previously.
Past. You said it previously has happened?
In
Something
the
like
past,
this?
past.
In the past, okay. Were drugs or alcohol related to this incident?
No.
If something happened in the future, would you feel comfortable in calling the police or 911?
Definitely.
Were there any minor children present during this incident?
No, ma'am.
I have one moment, Your Honor. No further questions.
And Ms. Gonzalez, Mendez, are you aware of... I'm sorry, Ms. Yurdi?
I'm sorry, I can't really hear you that
I'm
well.
sorry, can you say your last name again? I want to say it right.
My last name is Utria. I haven't legally
Utria.
changed it yet.
Utria. All right, Ms. Utria, are you aware of Mr. Gonzalez-Mendez's criminal history.
Yes, sir.
State, what are you asking me to do here? Because
We'll leave the contact in the court's discretion.
Mr. Thompson, I'm struggling right now because I'm struggling to grant you contact with Mr. Gonzalez-Mendez.
Sir, he is the head of the household. Like, I
understand that. I understand your financial reasons for that.
It's not even just financials.
Well, my concern is your safety. The allegations in this affidavit is that he punched you with a closed fist around a number of 15 times. He's had an exuberantly violent criminal history.
Yes, sir, I understand all of that. If I can just share a brief history, just really brief. We had came up from Miami to just change our life completely. He has been doing so well. He has anger. He has anger issues. I agree to that 1,000%. But we already discussed everything. We have couples therapy going on. Like, I cannot live without this man. I've never met I got married to him. So I really, really please need you to do anything that you can to just, please. I understand this is horrible and it's all my fault. It's really all my fault because I put myself in this predicament to where I called the police and I would feel
Explain to me, before you called the police, how this is your fault.
Because I texted another man. And he found out about it. But like I said, that's the only man that loves me and will accept me no matter what.
I want to make sure they got in your mind that it's all right for him to react that way because of that.
It's really not, but we discussed that. It's not, he understands that, and he understands that when his mother pressed charges on somebody on domestic violence, he wasn't, he was happy that she did that. So now he sees why he can't do that,
All right. Mr. Thompson.
We would ask for a bond in amount of $1,000 and a no hostile contact. And if the court he doesn't find that the no hostile contact is appropriate in this case, there's no objection to a no contact order, Your Honor, and any other modifications can be hashed out in the trial division.
Ms. Yuri,
Yes,
at
sir.
this time, until he can get in front of the division judge, which is Judge Shoemaker for this case, for a bond hearing, the court's going to order pretty much what I call a cooling off period. The court's going to order set bond amount of $1,000. Well,
So we can't do the no hostile contact?
Additional bonds will be no contact with the victim.
But he has nowhere to go.
He has to maintain a separate residence.
What can I do because he has nowhere else to go?
Man, there's nothing you can do because nothing you can do to convince me from what I'm looking at right here
I'm not going to show up to court. I'm not going to testify against my husband.
Well, ma'am, that's fine. But right now, I'm concerned about your safety. Even though you may not understand
I don't
that,
have
you may not
any.
be okay with that.
I'm not scared of him.
Ma'am, what's said has already been done, so you're only making things worse for us. So we will get in contact with our client and we could file motions and all these conditions could be relaxed, but it has to be downtown. Not guaranteed that it'll happen, but we have to take this case downtown. It's over and done with as of today. Okay?
He's possessing weapons of firearms. Any weapons of firearms he has, he's
There's
turn over
no
law enforcement
firearms.
within 24 hours. He's not to possess or consume any drugs or alcohol while out on bond. All right, ma'am. Have a great day. Sir, tell me your name again.
Irán Urrutia Ramos.
Mr. Urrutia Ramos, you are here in 2021 MM 472 AO on a charge of battery domestic violence. Is the victim here? Here you are. All right. So I'm appointing a public defender to represent you in this case. We're going to set your bond. Since you're not, or you don't have any contact with this state, and the amount of $1,000. Condition of your bond is not to have no contact with the victim. Must maintain a separate residence from the victim. Cannot possess any weapons or firearms. Without any weapons or firearms need to be turned over to law enforcement within 24 hours of your release. Not to possess or consume any drugs or alcohol while out on release.
Thank you.
Thank you, sir.
Have a great day, sir. Sir, tell me your name.
Frederick. Frederick Diaz.
All right. Mr. Diaz, you are here in 2021 CT 5701 AO on a charge of DUI with a breath alcohol above 0.15. The court has reviewed the charging affidavit. I did find probable cause for your arrest. I'm going to place you on pretrial release in this case. You are to possess no drugs or alcohol without a valid prescription. And don't operate a motor vehicle in the state of Florida without a valid driver's license. Have a great day, sir. Oh, sorry. Huh? No, for straight pretrial release.
Thank you.
Sir, tell me your name.
Angelo Gruline.
Is it Roland Diego?
Yes, sir. It's Delgado.
Delgado, I'm sorry, Delgado. Sir, you're here in 2021 CT 558 AO on charge of no valid driver's license. The court did find probable cause for your arrest. I want to stay your bonds, I think it's $250.
Sir?
Oh, this is Guerrillo Delgado?
Yes,
The
500,
offer is
sorry.
adjudication of guilt, credit for time served.
I wasn't necessarily inclined to not revoke his bond on the felony case. So I don't know if he wants to do that or not.
Can I have a moment?
I'm sorry. State would have no objection to leaving the bond as is. The defendant picked up a no valid driver's license while being out on a grand theft and possession. I'm sorry, grand theft, motor vehicle, and petty theft.
Yeah.
State, I just want to know, what was the offer for the new law?
Adjudication, credit for time served.
And Your Honor, you want to be taking any action on the out of bond charge, am I correct?
You got to give me an amazing reason as to why he picked up, he's out on bond on a grand theft auto, grand theft 2 prior possession of burglary tools case. He's still driving around without a license.
Well, I'm typically, as done at the BRC, that's when
I know what typically, I mean,
there's no reason I could give you, but if you're going to revoke his out on bond charge, I'm going to advise him, hey, he might as well just take care of everything downtown.
yeah. So I'm not really inclined to accept his offer in this case anyways. The court's going to stay the bond in the 2021 CT 558 case and 2020 CF 13864 AO case. The court's going to revoke his bonds as to that case. They'll set a new bond at none.
And the bond for the discharge is $250.
I'll set it $250. I think it's $500 on the affidavit.
All right. attorney trying to get a case okay, he revoked the bond on the out of bond, so he's gonna get out of jail. He revoked it because one of the conditions of being out of bond is you don't commit any new law violation. So you're not entitled to a bond. So the attorney that's assigned to that case is gonna get with you and talk to you about it.
When?
Talk about it. A couple of days.
Morning, sir. Tell me your name.
Charles Henry Beeson.
All right, Mr. Henry Beeson, you have two cases in front of the court this morning. You have 2021 MM 497 AO on possession of drug paraphernalia and 2021 CT 560 AO on a driving license suspended. You want to resolve these cases?
Say there's no objection to pretrial release.
All right, sir. The state has no. I was going to place you on pretrial release unless you wanted to resolve your case this morning. I'm going to place you on pretrial release this morning. Condition your pretrial release that you possess no drugs or alcohol without valid prescription. You're not consuming drugs or alcohol without a valid prescription. Random drug testing at your expense, and you cannot operate a motor vehicle in the state of Florida without a valid driver's license.
Okay.
I'll show you PTR on both cases. All right, I have Cindy Henry bonded.
Yes, Your Honor.
And then, sir, tell me your name.
Fernando Sanchez.
Theory Nertilis.
Yes.
Also bonded.
Theory Nautilis bonded. Yep, you got a $1,000 bond on FCA. All right, Mr. Sanchez, you're here in 2021 CT 561, the 2021 CT 562. The first count is no motor vehicle registration, and the second case is abuse or misuse of a tag. Is there any offer to resolve all three of his cases that he has?
The current one is adjudication credit for time served. Give me a moment to see if I can resolve the out on bond case. I don't have the is it 2020 is?
2021 MM
It's not in our system yet.
481.
That case is not in our system yet.
It's a notice to appear, so I don't.
So yes, we would not, I wouldn't have any information on that case yet.
And we don't have any else either
Yeah, can't you proceed on notice to appear?
They may be able to, I have
There's no information
I don't
at
have no
all.
information
Oh,
on
okay.
it.
All right. All right, Mr. Sanchez, to resolve your cases today, they're offering you adjudication of guilt, credit time served. Is that an offer you want to accept today?
Yes.
All right, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Then put your hand down, sir. Tell me your name one more time. Tell me your name one more time.
Fernando Sanchez.
Mr. Fernando Sanchez, you're here in 2021 CT 561 AO on charge of no motor vehicle registration. You're here in 2021 CT 562 AO on a charge of abuse or misuse of a temporary tag. Both of those are second-degree misdemeanors. Both of those are punishable by 60 days in the county jail and up to a $500 fine each. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to these two cases?
No contest?
You understand about entering a plea of no contest to these two cases? You're given the right to have a trial.
Yes, I understand.
You understand you're given the right to have an attorney appointed to represent you at a trial.
Understand.
At a trial, an attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. You understand that?
Understand.
You understand that by entering this plea that you're waiving your right to appeal any errors in this case.
Understand.
Are you under the influence of any drugs or alcohol at this time?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea if you're not a United States citizen, it could subject you to deportation.
Understand.
I reviewed your charging affidavits in this case. I do find a factual basis for the entering of your pleas. I'll accept your plea of no contest in this case. In 2021 CT 561, the court adjudicates you guilty as to the charge. I'll give you credit for the 2 days
Yes, yeah.
that you spent in the Orange County Jail with 2 days credit time served. The court cost of prosecution in that case of $306. In 2021 CT 562 AO, the court is going to adjudicate you guilty of the charge and give you credit for the 2 days that you spent in the Orange County Jail. And the court cost of prosecution in that case are also $306. I'll give
Total?
you, no, it's the total costs are $612.
Understand?
I'll order that you pay those costs directly to the clerk within 1 year of today's date. Do you understand that?
Yes, sir.
You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand?
Yes, sir.
All right, have a great day, sir.
Thank you.
And no action on the notice to
I'm
appear?
not going to take any action on the NTA case. All right, then I had Taylor bonded.
Yes, Your Honor.
I have Ernest Williams, correct?
Yes,
All right.
sir.
Good morning, sir. Tell me your name.
Ernest C. Williams, the fourth.
All right, Mr. Williams, you're here in 2021 CT 564 AO on a charge of driver license suspended. View the charging affidavit, do you find a probable cause for your arrest as that matter? Can we resolve Mr. Williams' case or
The
no?
offer is adjudication credit for time served.
Mr. Williams, you want to take that offer?
Sir?
You want to take that offer?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
Yes, sir.
Can you tell me your name one more time?
Ernest C. Williams, the fourth.
Mr. Williams, you are here in 2021 CT 564 AO on a charge of driver license suspended. That is a second-degree misdemeanor. It's punishable by 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
You want to enter a plea of guilty or no contest to this charge?
No contest.
You understand by entering a plea of no contest to this charge, you give up the right to have a trial.
Yes, sir.
You understand you give up the right to have an attorney appointed to represent you at a trial.
Yes, sir.
At a trial, an attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. You understand that? You understand that by entering this plea that you're waiving your right to appeal any errors in this case.
Yes, sir.
You understand that this charge can be used at a later date to enhance your sentencing. You understand that?
Yes, sir.
Are you under the influence of any drugs or alcohol at this time?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
I reviewed your charging affidavit as well as your driving record. I do find a probable cause for your arrest and your plea in this case. Sorry, that's why I found a factual basis for the plea or plea in this case. I want to adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in the Orange County Jail. I'm going to impose court costs and cost of prosecution in the amount of $306.
Yes, sir.
I'll give you 1 year from today's date to pay that money directly to the clerk. Do you understand that?
Yes, sir.
Have a great day, sir.
You too.
All right, ma'am, tell me your name.
Destiny Allen.
Ms. Allen, you are here in 2021 MM 471 AO on a charge of trespass and a structural refusal to leave. State. This one.
Withhold credit for time served, no return.
Ms. Allen, the state of Florida is offering you a withhold of adjudication and credit time served. You want to take that plea today?
I'm sorry, sir. I did not hear you.
Do you want it, the state is offering you a withhold of adjudication and guilt, credit time served. Do you want to take that offer today?
Your Honor, can I have a moment?
Sure.
Well, yeah, I was gonna ask if you all was, but you said this is the department. You gonna take them all? Your Honor, would you have any objection to an ROR in this case if she wants to buy her case downtown?
I have no objection to her having an ROR, but I need an address or a phone number. Do you have any one of those things?
Yes, sir.
All right. I need you to provide that information to to Mr. Thompson or his office. I'm going to order make a condition of your ROR because you're going to have a return date on your ROR, but you need to make sure you don't miss that return date. But you also need to keep in contact with your attorneys because I'm appointing the public defender to represent you. Do you understand that?
Yes, sir.
I need you to call them at least twice a month to make sure that you are keeping in contact with your attorney. Do you understand?
Yes, sir.
All right. If you lose contact with your attorney and we haven't heard from you, they're going to go find you and arrest you. Do you understand that?
Yes, sir.
All right. Have a great day, ma'am.
Thank you.
Good afternoon, sir. Tell me your name. Sorry, good morning, sir. Tell me your name.
Good morning. My name is Pedro Castillo.
Mr. Castillo, you are here in 2021 MM495AO on charge of, you have 3 charges in which you're arrested for. 1 charge petty theft, resisting officer without violence, and providing false information to a law enforcement officer. I want to ask the state if they have an offer to resolve your case.
We do not.
State of Florida does not have an offer to resolve your case at this time. I'm going to appoint a public defender to represent you in this case, looking at your out-of-state history, including theft and similar charges and convictions. And your ties to this community are very slim. So the court's going to stay your bonds as set, 500, 1,000, and 1,000 for a total of 2,500. So the condition of your bonds that you do not return to the scene of this location. You understand? No contact with any victims or witnesses.
No contact with who?
No contact with any victims or witnesses from this case.
Okay. So I have to pick on him.
Tell me your name, sir.
Like Ryan Doble.
Mr. Doble, you are here in 2021 494, 2021 494 on, you were arrested for a charge of petty theft.
Yes.
State, you have a...
There is not an offer in this case.
All right, there's no offer in this case. Looking at your history as well. Several Florida convictions and out of state. And you're already out on pretrial release in another case. So the court's gonna say the bonds is set an amount of, I think, $500, correct? The amount of $500. Condition of your bond in that case is that you not return to the scene of this location. No contact with any victims or witnesses from that case. You understand?
Okay, so does that mean I get to leave today?
They're not offering you a plea today.
So no, do I stay here?
Yeah, you're gonna be here with us because I'm gonna revoke your PTR in 2020 CF 14539AO.
Right. So I'll stay here.
Yep.
For a month.
Until you get into your, I don't know when your next court date is for your felony case. But
And then for the other case, when I go to court for that, then I'll leave probably.
Maybe you gotta get in front of your felony judge and your new misdemeanor judge. I'm gonna appoint a public defender to represent you in this case. So make sure you speak with your public defender and keep in contact with them and make sure they have all the information they need to defend you. You understand?
Okay.
Have a great day, sir. Yes, ma'am. This is 20. You want to fight about to break it the other day. We need to find a better system, sound like. I know, as I said, they need to come give a new scanner. That's what I did the other day. When you want to work. Maybe a new paper. It's too old. That's what it is. Sir, tell me your name. Tell me your name.
Nega. Full name. Georgian Nega.
All right, Mr.
Georgian
Nega.
Constantine Nega. Yeah.
Mr. Nega, you are here in 2021 MM468AO. We were arrested for simple trespass. Stated an offer for Mr. Nega.
So withhold credit for time served, no return.
Mr. Nega, the state of Florida is offering you a withhold adjudication of guilt, credit time served in this case. Is that something you want to take today?
I'm sorry.
No?
I don't understand.
Do you need an interpreter?
Yeah, I think I did. Because I don't understand.
Espanol? What language?
Yeah, English also, but I don't understand. And I'm a little scared because it's the first time when I'm here, so.
All right.
I don't know what's going on.
I'm going to represent you. I'm going to have Mr. Thompson come speak to you.
Yeah, do you have any objections to an ROR in this case? This appears to be his first arrest. He's 41 years old, no criminal history whatsoever.
All right. I'm agreeable to that. Mr. Nega, you have a address or a phone number you can provide to us? You have a phone?
Home?
A phone. They got a telephone.
Phone? No, because they stole my phone. I had it, but no, I don't have any more because they stole it. They steal it. Somebody steal my stuff.
All right. Are you going to get it back soon?
If I get the same phone back?
Yeah, I'm going to get a phone back. Some phone. Any phone.
Phone? Yes, I think so. Yeah, I think.
All right.
I assume, but...
I want to do this, so listen to me. Make sure you understand. I'm going to release you on your own recognizance. All right?
Yes, sir.
That's an agreement between me and you.
Yes, sir.
You're going to return back to court when they tell you to come back.
Okay, but...
Wait. Let's listen to me. I want to make sure you understand. I'm going to appoint the public defender to represent you. So they're going to be your attorneys. Okay? They have the largest office here in Central Florida for defense work. You need to keep in contact with them. So twice a month. Look at me. Twice a month. You need to either call or go by their office and meet with them. You understand?
Okay.
To make sure that you're updated on all the things that are going on.
Okay.
Because if you miss court, the judge is going to send the sheriff's office to come arrest you. You understand that?
Yeah, but...
I know you may have issues about whatever happened that today. That's not the time to resolve it. I need you to follow my directions so you don't get rearrested. You understand?
Okay. And
you understand me?
Yeah. And for how long will be this? Speaking about the twice a month?
Until the judge tells you the case is dismissed, or you take a plea, or you go to trial. Okay?
Okay.
This is our phone number. Call us. All right?
Okay. That's the phone. Let me see if I see 4078
836 4800. Let me write it there for you.
Okay, thank you very much. And when I need to call?
Today actually.
Oh well, I don't have a cell phone.
Well, whenever you get a phone.
Oh well, today?
It could be today or tomorrow, whenever.
Oh well, I don't have a cell phone. Where am I?
I said, go by their office.
Or come by our office.
What is the office?
Let me give you this is our address right here. That's our address.
Just a second.
Is that the courthouse?
Not Orange Avenue?
Yeah, 435 North Orange Avenue, Suite 400.
Oh, well, what is that?
The downtown courthouse.
Downtown?
Yeah, so go to the courthouse downtown. Ask him where the court defender's office at. And
He's building bigger one, so.
So where do I have to go? Today, tomorrow? When?
Whenever you get a chance.
Take him outside, please.
Right.
I'm scared.
Go ahead, let's talk to him. Make sure he understands. Good morning. Sir, tell me your name.
Jordan Robinson.
All right, Mr. Robinson, you are here in 2021 MM41 and 2021 MM42 on charges of trespass, trespassing a conveyance and resisting officer without violence. Stays in all of the resolved in these cases.
Now, Mr. Robinson's case on the resisting is adjudication credit for time served, and on the trespass and adjudication credit for time served, no return.
Mr. Robinson, do you want to take that offer from the state of Florida?
Yes, sir.
You raise your right hand and be sworn in. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
Yes, sir.
You put your hand down, sir.
One thing, Your Honor.
Yes, ma'am.
I just want to make sure the defendant is still on juvenile probation.
Not anymore to what I know. I was doing I was supposed to turn my community service in yesterday, my papers. That would have completed my thing, but I didn't make it.
Well, I can't do anything with me.
Put it on record.
Yeah.
Okay.
I can't do anything about that anyways, unless they send me a custody order for him. So, which looks like you're over 18. So.
Well, I'm 18.
Yeah, as I said, you're over 18, but I didn't know if they can hold in certain charges. They can hold you.
No, like on my hold, it said I had a hold, but they took it down. That's what stopped my bond. But they told me I don't have a hold anymore.
Yeah, I'm saying like I don't know what the orders were for your probation. Were you on probation until you're 21, or it stopped when you were 18? I don't have no idea. So.
Oh, I think it's till I'm 19.
Yeah.
Till he's 19.
Yeah,
Until he's 19.
All right. But in this case, you want to resolve these cases, other question.
Yes.
All right.
Your Honor, out. Your Honor,
Yes, ma'am.
would you have any objections to pretrial release?
It doesn't qualify. But
Not while he's on juvenile probation.
Oh, he's not.
yeah, he doesn't qualify. I mean, looks like he was here shortly after he turned 18, I'm sorry, for trespassing and criminal mischief back in October.
Your Honor, we would ask for a $500 bond.
Total, or you just asking me for?
No objection, 250 on the
That's what I'm
4-1
asking you.
case, and then 250 on the 4-2 case.
All right. I have no objection to that. All set his bonds at $250 on each of his cases. As to the trespass case, no return to the scene of the location of. Well, no contact with the victim. It's another juvenile type case.
So no return?
Well, there's no contact with the victim. All right, Mr. Robinson, you are an extremely young man.
I can't hear you, sir.
You're extremely young. All right. Like, what happened in this affidavit is the same foolishness that got you caught up when you were in juvenile court, right? So why keep? Hey, no talk. Just like why keep doing it? You should ask yourself in your mind, like when somebody asks you to get in a car with like to do anything, why? Unless you going to work or going to church or going home, you may want to think about catching public transportation or Uber or something, because you hang out with knuckleheads, you'll get you caught up.
Yes, sir.
All right.
Yes, sir.
All right. Have a great day, sir.
You too.
All right, sir, tell me your name.
Bruce Taylor.
All right, Mr. Taylor, you are here in 2021 MM 474 AO. Charges 2 counts of resisting officer without violence and trespass in a structure refusal to leave. State is that offer to resolve his cases.
Adjudication of guilt, credit for time served, no return.
Sir, The state of Florida is offering you an adjudication of guilt, credit time served, and offer you'd like to take today.
I didn't hear anything you said. I
Is there
can't hear you.
The offer from the state of Florida is an adjudication of guilt, credit time served. Is an offer you want to take today.
Yes.
You want to raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth to help you God?
Yes, sir.
Sir, you're here in, can you tell me your name one more time? Put your hand down and tell me your name.
Bruce Taylor.
All right, Mr. Taylor, you are here in 2021 MM 474AO on charge of resisting officer without violence and trespassing a structure or refusal to leave. Both of those charges are first-degree misdemeanors. Both of those charges are punishable by 1 year in the county jail and up to a $1,000 fine each. Do you understand that?
Yes, I do.
You want to enter a plea of guilty or no contest?
No contest.
You understand by entering a plea of no contest, you give the right to have a trial.
Yes.
You understand you give the right to have the court appoint an attorney to represent you at a trial.
Yes.
At a trial, an attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. You understand that?
Yes.
If there was a witness that you wanted to call that did not want to appear for court, do you understand that the court can use the subpoena power to make that witness appear?
Yes.
Are you under the influence of any drugs or alcohol?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes.
Sir, I did review the charging affidavit in this case. I do find a factual basis for your plea. I will accept your plea of no contest. I'll adjudicate you guilty of the charge. I'll give you credit for 2 days that you spent in the Orange County Jail. The court costs the cost of prosecution of $273. I'm going to order that you pay those costs directly to the clerk within 1 year of today's date. Do you understand that?
Yes.
You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Yes.
Have a great day, sir.
Young bonding, Your Honor.
All right. Young bonded. All right. What you got? My jail stamping for you. Sir, tell me your name.
Good morning.
Tell me your name, sir.
My name is Martin Flanagan.
Mr. Flanagan, you are here in 2021 MO 117 on a charge of disorderly conduct. State, you have an offer?
Withhold credit for time served.
All right, Mr. Flanagan, the offer for the state of Florida is a withhold adjudication guilt, credit time served. An offer you want to take?
Yes, ma'am. Yes, sir.
Can you
Yes,
raise
Your
your right
Honor.
hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
So help me God, I do.
Put your hand down. Tell me your name again.
Martin Flanagan.
Mr. Flanagan, you're here in 2021 MO 117AO on a charge of disorderly conduct. That's a second-degree misdemeanor punishable by 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to this charge?
No contest, Your Honor.
No contest, Your Honor.
Do you understand that the court accepts your plea of no contest, you give the right to have a trial?
Yes, I do.
You understand you give the right to have the court appoint an attorney to represent you at a trial?
Yes, I do.
Are you under the influence of any drugs or alcohol?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
I am a citizen.
Well, do you understand? I gotta warn you.
I understand, yes.
All right, sir, I reviewed the charging affidavit in this case. I do find a factual basis for the entry of your plea. I'll accept your plea of no contest. I'll withhold adjudication of guilt. I'll give you credit for the 2 days that you spent in the Orange County Jail. And I will impose court costs and cost of prosecution amount of $273.
Yes,
Mr.
sir.
Flanagan, do you work? Any
No,
city
sir.
income?
No, sir.
All right, I'll reduce those costs of judgment.
Thank you, Your Honor.
You got 30 days to appeal this, my judgment and sentence. You understand that?
Yes, I do.
All right, have a great day, sir.
Thank you.
All right, sir, tell me your name.
State your name.
Raymond Rosado Acevedo.
All right, Mr. Rosado, you are here.
Panhandle.
In 2021 MO 118 on a charge of panhandling. Say you're an offer.
The offer is a withhold credit for time served.
Have a moment, Your Honor.
Sir,
Yes, sir.
you want to accept that offer of withhold credit time, sir?
Yes, sir.
Can you raise your right hand to be sworn in?
Yes, sir.
Can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
Yes, sir.
Put your hand down. Tell me your name one more time.
Raymond Rosado Acevedo.
Sir, you are here in 2021 MO 118 AO on a charge of panhandling. That is a first-degree misdemeanor. Second-degree misdemeanor punishable by 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you understand? You want to enter a plea of guilty or no contest?
Yeah, guilty, sir.
You understand? When enter a plea of guilty, you give the right to have a trial.
Oh, so no contest is.
No, do you understand? I'm going to go over your rights.
Yes, sir.
All right. So one of the rights you're giving up when entering a plea is the right to have a trial. Do you understand that?
Yes, sir.
One of the other rights is that you're given the right to have the court appoint an attorney to represent you. Do you understand that?
Yes, sir.
Are you under the influence of any drugs or alcohol?
Yes, sir.
You're under the influence of drugs or alcohol?
I'm not.
I'm asking.
Yes, sir.
All right. Do you think that is that affecting your ability to understand what I'm saying and what's going on around you?
No, sir. I understand, but I don't.
All right. Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter a plea?
Yes, sir.
Has anybody forced, threatened, or coerced you to enter a plea?
Yes, sir.
Somebody's making you do this?
No, sir.
I'm asking you.
No, sir.
Is anybody making you do this right now?
I'm good, sir. Yes.
Yes?
Yes, sir.
Who's making you do this?
No, he said.
I don't understand. No, I don't understand. I understand, but I don't understand better. No, sir. No, sir.
Okay, so
No, sir.
after talking to Ms. George, you understand my question?
You understand the question?
This question, no, I don't understand.
He's asking you if you understood the question he asked you.
Yes, sir. I understand the question.
All right. Do you understand if you're not a United States citizen, it could subject you to deportation?
Yeah, I understand it.
All right. I reviewed the charges and affidavit. I do find a factual basis for the entering of your plea. I accept your plea of guilty in this case. I will withhold adjudication of guilt, and I will impose court costs amount of $273.
Yes, sir.
I'll reduce those costs of judgment. I won't take any action on your out of bond case, and you have 30 days to appeal.
Thank you.
David Alexander is mental health, Your Honor.
On board the public defender represent Mr. Alexander in 2021 CF 822AO. The court did find probable cause for his arrest in both charges. Do you want to waive his appearance?
Yes, we'll waive, Your Honor.
I want to set bonds in the amount of $1,500 as to count 1, $500 as to count 2, or an alternative, if he qualifies for mental health pretrial release, I'll release him on straight mental health pretrial release. All right. What happened to Freddie Brown?
Freddie Brown is
Who's his? W2?
It should be Maria Alvarez. Yeah.
All right, you didn't look like a Freddie Brown to me, so. Ma'am, tell me your name.
Maria Alvarez.
All right. Ms. Alvarez, you are here in 2021 CF 575AO on charge of a warrant that was signed on charge of petty theft to prior. The judge set your bond at $1,000. There's conditions of your bond that you have no direct contact with any victim, co-defendant, or witness, and to not return to the scene of the location where this incident happened. You understand?
Yes, sir.
All right. No, because there are other cases on here, so I don't know what these other cases are.
This case that she's being seen on today was an add-on.
Okay. All right, ma'am. Have a great day. All right, sir. Tell me your name.
Freddie Donnell Brown, sir.
I'm sorry. And sorry. In Miss Alvarez's case, I'm appointed public defender to represent her. All right. Sorry, sir. Tell me your name.
Freddie Donnell Brown, sir.
All right. Can we have I think Young is the other case. Can we do Young at the same time, or we're gonna do one at a time?
The first name on the
He's in my VOP section.
I don't see it yet.
I thought I had a Young.
I don't have a Young, Your Honor. I don't have a Young.
Are you referring to Marie Young?
Hold on. No, I thought it was Thompson. Sorry, Thompson. Apologize. Thompson's co-defendant in this case. I thought it was.
Hirsch, is that Herschel?
Yep.
Failure to appear, it's in the felony, regular felony.
Yeah, he's in there somewhere. There he is. Herschel Earl Thompson. I explain things first. Find a problem cultural evidence. I know that. COVID. Yeah. Alrighty. Alright. So I got Mr. Brown, and I now have Mr. Tell me your name, sir?
Thompson.
Alright, tell me your full name.
Herschel Thompson.
Alright, Mr. Thompson. Alright, you two are involved in the same incident, so I can find probable cause at one time. Mr. Brown, you were here in front of me in 2021, CF 821AO. In that case, you've been charged with possession of with a firearm by a convicted felon, possession of MDMA or ecstasy, and grand theft of a firearm. I did find probable cause for your arrest in that case. In 2021, CF 820AO, Mr. Thompson, you were arrested for carrying a concealed firearm or weapon by a convicted felon.
Hold on.
Huh? Driver license suspended as habitual traffic offender, and possession of drug paraphernalia. I found probable cause in that case based on the same incident that was involved with Mr. Brown at the same time. As to Mr. Brown, I'm going to set your bonds I'm gonna stay your bonds as set in the charging affidavit in the amount of $5,150 as to your 3 counts. You're out on bond in 2020 CF 14848 AO. The court's going to revoke, constrict, and forfeit your bond in that case and set your new bond at none. I'm going to order that you have no contact with Mr. Thompson, who's standing to your left. So I'll make sure you guys both understand that. Because both put condition your bonds, and while you're here in jail, that you guys are not supposed to have contact with each other. All right, I'm going to appoint a public defender to represent you in both your cases. They're going to withdraw from your case, and the court's going to appoint either a regional conflict counsel or you're a private attorney. But I just want to let you both know that it's not there right now. So we both going to have attorneys, but this may not be the same attorney, all right, from the same office.
Sir.
All right, Mr. Thompson, in your cases, I want to stay your bonds as set in the charging affidavit. Find that. Yeah, and it's $5,150 as well in your case. All right. Well, condition of your bonds, you had no contact with your co-defendant or your other witnesses in this case. With me and Mr. Brown. And you were arrested also on a failure to appear warrant in 2020 CF 11102 AO. The court in that case set your bond at none. You are out on bond in 2020 CF 11702 AO.
Here this guy.
And in that case, the court's going to revoke your bond and set your bond at none.
So,
look, you gotta cover your face and nose.
I can't, like,
there you go.
I don't, so on the FTA, right?
Yes, sir.
I never received a court date.
I understand that.
So,
you gonna work
then
that
why
out?
don't give
You
me
gonna
no
work that out
bond
with your attorney? Apparently you have a private attorney on that case. So you're paying somebody to tell you what the court date was, so you may want to go talk to them about that. But in your other cases, I'm gonna appoint a public defender to represent you, so you can get bonds and bond hearings on those cases.
I didn't. I understand. So I got no bond right now.
As to 2 of your cases, but one of your cases does have a bond. Have a great day, sir. Sir, tell me your name.
Raymond Calderon.
Mr. Calderon, you are here in 2021 CF 815 AO on a charge of petty theft with 2 prior theft convictions. You are here in 2021 CF 742 AO on a charge of burglary of a dwelling, grand theft of motor vehicle, and petty theft. The judge in your in 742 found probable cause and set your bonds as follows: 5,000, 1,100. Condition of your bond, the court is going to add that you do not have any contact with any victims or witnesses and do not return to the scene of the location. As to the petty theft 2 prior charge, the court will stay your bonds at $1,000. I'm going to make a condition of your bond that you do not return to the scene of the location where this happened. You're out on bond in 2020 CF 6232 AO when these offenses occurred. The court's going to revoke your bonds in that case and set your bonds at none.
You say I was out on bond, sir?
Yes, sir. That's what they told me. And possession of.
Okay, yes, sir, yes, sir. Talking about I have a warrant for possession of marijuana.
No, you have a possession of controlled substance case that you're in pretrial diversion status. Your bonds had not been lifted at that time, so.
I ended up paying the fine and doing the class. I don't know if they cleared it yet, but I don't know what else to say about that.
Ms. Swanson, did you all?
But anyway, so yeah.
Enter an order dismissing that case after its completion of the program?
No, I see that he's in diversion, but I don't know that it's completed.
Yep. So I'll appoint a public defender to represent you in this case. Maybe they can do some investigating and work out whatever happened to your other case, all right? All right, have a great day, sir. Good morning, sir. Tell me your name.
David Merle Collins II.
Mr. Collins, you are here in 2021 CF 313AO on a charge of failure to register as a sex offender.
I was in I'm sorry.
Appointed public defender's office to represent you in this case. The judge signed your warrant, previously found probable cause, set your bond at an amount of $5,000. Making condition of your bond that within 24 hours of your release from the Orange County Jail that you go to the Orange County Sheriff's Officer and register.
Yes, sir.
You understand that? You are out on bond in two cases.
Yes,
First
sir.
case 2020 CF 77AO, and second case in 2020 CF 2835AO.
Yes, sir.
The court is going to revoke your bonds as to those cases, set your new bond at none.
Sir, can I say one thing
Sir,
real quick?
you talked to Mr. Thompson. I was appointing him to represent you. Yeah, before you speak to me, you talk to him.
Your Honor, would you have any objection to possibly taking no action on the out on bond charge or revoking and setting new bonds? I say that because yes, this is a crime. However, it's not like a theft or a robbery or various things like that. I mean, what's alleged is that for whatever reason, he just failed to report a new. He failed to report a new address.
So, Mr. Thompson, this is a third-degree felony.
Yes.
With some of them with level 6 or 7 on a score sheet. So I don't know how serious of a third-degree felony, other than making them a second-degree felony, it could possibly be. It scores automatic prison. Am I not correct in that?
Yes, you are.
So, it's a tedious thing to be a sex offender or a sexual predator in the state of Florida. They make it very hard. But if you decide to live in the state of Florida, there's certain states that it expires. You stay out of trouble for 10 years, you don't commit any new offenses, you don't have to register anymore. There are plenty of states like that. I think Pennsylvania is one of them. So, you know, state of Florida saying if you want to be here, if you have alleged to have committed those crimes, not alleged, but you're convicted of those crimes, sexually motivated crimes, that you're required to register. So, I don't think it is a non-violent or non-serious crime discharge. So I want to state my ruling. You can file a bond motion in front of your judge. They may have a different take on it than I do.
Thank you, Your Honor.
How do I do that?
Sir, tell me your name.
Jeffrey Ford.
What happened to David Collins?
Pardon?
Where is he supposed to be? All right, David Collins. No, sorry. This was David Collins.
David Collins.
She didn't yell at me to take. She didn't come snatch my paper away. So.
I doubt my
All right, sorry, Mr. Ford. Good morning. How are you?
Very good, sir. Thank you.
All right, sir. You're here in 2020 CF 1459 for failure to appear. The judge in that case set your bond at $2,500. Bond remain as set. And you have a private attorney? Who? All right. Make sure you keep in contact with Mr. Luca. Let him know you're here, and if you need to take any other actions. All right.
Okay. Yeah. Was not aware there was a that was a failure to appear. I didn't was not aware I had a court date, so I don't know how I could appear.
That's
for a court date that I
the
wasn't.
failure to appear is very simple. They told your attorney, and your attorney was on notice, and you didn't show up. You're deemed to have notice. So that's how they looked at it. That's how the law looks at it. So even though it was that as crazy as that is, that's the way it is. So can get in front of your judge, they may lower your bonds, or talk to Mr. Luca, he may be able to make that happen in an expedited fashion, okay?
Okay.
All right. All right, sir, tell me your name.
William Finney, sir.
Mr. Finney, you are here in two cases. The first case is 2021 MO 116 AO on charge of alcoholic beverage or open container in a prohibited area. In 2021 CF 813 AO, you got 5 counts. 2 counts of battery of a law enforcement officer, 2 counts of resisting officer with violence, and 1 count of resisting officer without violence. I did find probable cause for your arrest as this matter. I'm going to appoint a public defender to represent you in this case. I'm going to set your bond and count 1, reduce it to $1,000. I'm going to leave the rest of the bonds as set, 150, 150, 150, 100. As to the 2021 MO 116 case, what is that, set it? I reduce that to 100. All right, sir. You have a public defender representing you. Maybe you can get in front of the
How much, Your Honor? How much was the bond?
total.
Yeah. Oh, okay.
300, 450, 550, 650, $1,650.
Okay, thank you.
James Garcia refused, Your Honor.
All right, I'm going to appoint the public defender representative, Mr. James Garcia. He's here in front of me in 2 matters, 2021 CF 753 AO, and then 2021 CF 795 AO. You want to waive his appearance?
Yes, we'll waive, Your Honor.
All right, waiving Mr. Garcia's appearance, I'm going to, I did find, there's a warrant. Yep, judge found a warrant, signed finding probable cause. All these bonds is set, 3,500 is account 1, 1,000, and 1,000. No return to the scene as a condition of his bond, no contact with any victims or witnesses. As to 795, the judge found probable cause, set his bond at $1,000. No contact with the victim in that case. All right, sir, tell me your name.
Anthony Heir.
Say it again.
Anthony Heir.
Mr. Heir, you are here in 2020 CF 14429 AO on charge of attempted first-degree murder with a weapon. State.
Yes, Your Honor, we filed information on this case.
You did?
Yes. So count 1 is attempted first-degree murder, life felony. Count 2 is attempted first-degree murder, life felony, with the weapon, both of them. And then count 3 is aggravated battery with a deadly weapon or causing great bodily harm. State would ask that he's held at no bond on counts 1 and 2. You don't have the information? Do you need the information?
Yeah, there's only 1 count in the warrant. I guess he has 2 more counts.
But we actually filed.
You have a copy of the information, right?
Yes, may I have
or is
1
it one in the system?
We have to go by where they're booked.
Yeah, but if I don't want to sign him bonds as his other counts, you don't be back there on bond here.
So they'll have to add the count into the system.
Yeah, so as long as I got it. Is there information in
I said that
Odyssey?
according to my system, we filed it on January 15th.
Ms. Davis, do you see the information in Odyssey for them?
I mean, I see it in the clerk of courts.
Yeah.
The 3 charges, yes.
All right.
Your Honor, we're not
Yes,
going to
sir.
make an argument. We're going to reserve the right to have an Arthur hearing downtown.
Okay.
I just want to make sure that we set bonds, because obviously.
Yeah, that's what I said. I want to make sure that the
Okay.
bonds are set on the, because what will happen when you get downtown, like at some point, somebody like, hey, judge, nobody set bonds on these 2 counts, and nobody, you guys won't release him because he's now facing his other charges.
So we request no bonds on count 1 and 2, and
All right, the
then
court's gonna set no bond as to counts 1 and 2 in this case. states the defense is not asking me to find proof evidence presumption great at this time. As to count 3 of the information, which is aggravated battery with a deadly weapon. Is it alternative or just aggravated battery?
Just in the alternative.
All right. Aggravated battery with a deadly weapon or causing great bodily harm. The court is going to set bond in an amount of $25,000. Condition of his bonds, even while he's in custody, is that he's to not have contact with any of the victims in this case, including his ex-wife. He's to have not returned to the scene of this location, to possess no weapons or firearms. He is to, any weapons or firearms need to be turned over to law enforcement within 24 hours of his release. He's to turn over any passport that he has in his possession, U.S. or Jamaican national in origin. Prior to his release. All right, that's it for Mr. Heir. Now appoint the public defender to represent him.
Thank you.
Sir, tell me your name.
Ernest Hartfield.
Mr. Hartfield, you are here in 2021 CF 816AO on charge of possession of cocaine and possession of drug paraphernalia. I did find probable cause for your arrest as to that charge. The court's going to state your bonds amount of $1,100. State what did you say to the out on bond case?
No action, Your Honor.
Of course, not going to take any action to this out on bond case, the 2020 CF 4125AO. Mr. Hartfield, there are resources here in our community, there are resources out here at the jail, at the courthouse, if you think you have a substance abuse problem that you want to get under control. But if you get arrested for a 3rd time for the same offense, you're going to be hanging out with me for a while. Do you understand that?
No, sir, I couldn't understand you, sir. I couldn't hear you, sir.
There are plenty of resources out here in the community to help people with their drug abuse and drug addiction problems. Here at the jail, downtown at the courthouse, and elsewhere in the community. If you're having problems, you should go look at one of those resources to help you overcome this issue. If you come before the court again on another arrest, I could hold you without bond right now, but I chose not to. But if you come back here again, you're gonna be sitting here with me until your cases are resolved. You understand that?
Yes, sir.
All right, have a great day. All right, ma'am, tell me your name.
Amy Marie Love.
All right, Ms. Love, you are here in 2020 CF 9187AO for a failure to appear. Of course, your bond is set at none. The bond remain at none until you can get in front of the appropriate judge to handle your case. You understand that? Yep. That's how I saw that. You got the public defender on your case, so you can maybe get in front of the judge quicker than usual, okay? Tell me your name, sir.
Bruce Madison, sir.
Mr. Mason, you are here in 2021 CF 818AO on charge of counterfeiting a license plate. The court did find probable cause for your arrest as to that charge. The court's going to stay your bonds as to that charge in the amount of, I think it was $1,000. You are out on bond in 2019 CF 12273. The court's going to find you violated your bond conditions by probable cause of committing a new law offense. I'm going to revoke your bonds as to that case and set your bond at none. Going to appoint a public defender to represent you in all your cases.
Sir, but I've been out a whole year. The car's not in my name. I didn't know nothing about no paper tag being messed up on the car. I got licenses. I haven't been doing no trouble. I work.
All right, talk to your attorneys and then get you in front of the judge to have the appropriate bond hearing. All right, sir, tell me your name.
Christopher Andrew Mercado.
Mr. Mercado, you are here in 2021 CF 802 AO on charge of possession of methamphetamine. You're also here in 2021 MM 492 AO on charge of trespass. Court reviewed the charging affidavit, did find probable cause for your arrest as to those charges. I'm going to stay your bonds as the felony count as to $1,000. I'm going to set your bond in the trespass count at amount of $100. Your out on bond in 2020 CF 7415 AO. Of course, it's going to revoke in the street and forfeit your bonds. In that case, it's going to set a new bond at none.
So I can bond out?
Not as to the old case. I'll appoint a public defender to represent you in that case, in all your cases. Then get you in front of the appropriate judge to have a bond hearing. Tell me your name, sir.
Tavares Servant.
As a servant, you are here in 2021 CF 817 AO on charge of Raul as suspended as a habitual traffic offender. Court did find probable cause for your arrest as to that charge.
I'm sorry, I can't hear you.
I found probable cause as you're arrested as to that charge. Going to stay your bonds in the amount of $2,500. You're out on bond in 2020 CF 8081 AO. Of course, going to revoke your bonds in that case. It's going to set your bond in the amount of $5,000.
How much? What did you say? 5,000? You can set a new bond of 5,000?
Tell me your name, sir.
Mark Bernardo.
Say your name again.
Mark Bernardo.
Mr. Bernardo, you are here in 2020 CF 15356 AO. 2 charges: aggravated assault with a deadly weapon and battery. Judge signing your warrant found probable cause for your arrest. Going to set bond in count 1 in amount of $2,500. Count 2, I want to stay at $500. I'm going to make a condition of your bond. I set your bond in count 1 at $2,500. Count 2 is set at $500. So $3,000. Condition of your bond: you had no contact with the victim. All right? No contact. Must not return to the scene. You guys cannot possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You understand that? Have a great day, sir. Tell me your name, sir.
Vasquez Omar Vasquez Colon.
All right, Mr. Vasquez Colon, you are here in 2020 CF 5734 AO on charge of a warrant for failure to appear. The judge set your bond at none. Your bond will remain at none until you get in front of the judge that signed the warrant. I'll appoint the public defender to represent you in your cases. Have a great day, sir.
Jose Velasquez, medical urine.
I'm going to appoint a public defender to represent Mr. Jose Velasquez in 2021 CF 819 AO. You all want to waive his appearance?
Yes, Your Honor, we'll waive.
Ms. Davis, does he not qualify because of
The outstanding warrant.
his outstanding warrant? I was trying to figure out what that was. Okay, the New York Jersey warrant. But if I order it, can I make it happen?
It's up to you, Judge.
All right, I'm going to try to release Mr. Vasquez on straight pretrial release. Condition of his pretrial release that he's to not possess or consume any alcoholic beverages or controlled substances without a valid prescription. And he is to be random drug tested at his expense. All right, tell me your name, sir.
Christopher Martin.
All right, Mr. Martin, you are here in 2018 CF 3631 AO on a violation of probation. The judge signing your warrant sets your bond at none. Your bond will remain at none until you are brought before the judge to sign the warrant. I'll appoint a public defender to represent you in your case. All right? Have a great day, sir.
You said I have a public defender?
Yes, sir.
I have a paid lawyer.
On the violation of probation or on the old case?
The whole case.
All right, so when the case ended, when you pled or you went to trial, that representation is done. So you don't have a lawyer right now. So I'm going to appoint a public defender to represent you until you may rehire the same lawyer, but you got to call them and make a new agreement, okay?
I talked to him yesterday. He's finna do my violation of probation also.
All right. Once he files a notice of appearance, then the public defender will come off your case, all right? But I want to make sure you have a lawyer before, like, you walk out the door without having a lawyer, because you could sit in jail for a while if you don't have anybody representing you, okay?
All right.
Yeah. All right, sir, tell me your name.
Hello, sir. My name is Jonathan Gumbo.
Mr. Gamo, you are here in 2019 CF 9782 AO on a violation of probation. The judge assigns your warrant. In that case, sets your bond at none. You're also here in 2021 MM 499 AO. The court reviewed the charging affidavit. In that case, a found probable cause. Your bond will stay your bond amount of $500. I'm going to appoint the public defender to represent you in your case. I'm appointing the public defender to represent you in your case.
Okay.
And you'll file appropriate bond motions in your felony case if you need it, okay?
You say I have no bond for the violation of probation?
Correct, sir.
How can I get out that situation?
You got to talk to appointing the public defenders to represent you. They got to file a bond motion in front of the court, and then the judge will decide whether to release you or not.
Can I do a PR?
You want to represent yourself?
No, like I want to do a well, I don't want to represent myself, but I just any ways I can, because I have $2 right now and they need me, and any way I can get out.
Well, I don't want to put you in a precarious situation. The law technically says that I possibly could change the VOP warrant, but then as soon as I do that, the judge that signed the warrant can turn around and revoke it and rearrest you in front of your daughters and all that stuff like that. So I'd rather you stay here with us and you get in front of the judge in the next week or two versus having to go in and out for that reason. You understand that?
Am I allowed to ask for, like, if I wanted to be deported from this country, can I do that?
I don't know. If you have an immigration hold, then possibly.
I'm tired of America. Okay. So just talk to my PD about
Yep,
the
talk to
next
your
court. Okay, thank you.
All right, have a great day, sir. All right, sir, tell me your name.
Gabriel Reyes.
Mr. Reyes, you are here in 2020 CF 9357AO on a violation of probation. The judge signing your warrant set your bond at none. Your bonds will remain at none until you get in front of the judge that signed the warrant. I want to appoint the public defender to represent you in this case. Yes, ma'am.
I'm sorry, Your Honor. He actually has a $5,000 bond.
Oh, you're correct. That's what I meant. Sir, you do have a $5,000 bond in this case that you can't post. If you like, I still appoint the public defender to represent you. Just in case you can't post it, it'll get you in front of that judge as quickly as possible. All right.
Thank you, sir.
No problem. Have a great day. I had David Guile bonded. Sir, tell me your name.
Luis Garcia.
Mr. Garcia, you are here on an out-of-county warrant for Seminole County. The judge signing your warrant set your bond at none. Your bond remain at none until Seminole County comes to pick you up. You understand that?
I understand that.
I'm going to appoint the public defender to represent you just in case you stay with us a little bit longer than usual, okay?
Your Honor, is there any way I can say something?
I suggest you not. Everything we say is being recorded, and you may not be really helping yourself, all right? Sir, tell me your name, sir.
Anthony Lee, Emmanuel Grady.
All right, Mr. Gray, you are here in an out-of-county warrant, I believe also from Seminole. Sure. From Seminole County, in a felony case. The judge in that case set your bonds at none and all your charges. Your bonds remain at none until you can get in front of that Seminole County judge. Seminole County should be about to pick you up in the next week or so.
You said bonds getting transported, right?
Yeah, you should get transported. They were here Tuesday picking up people, so.
All right, appreciate it.
They should get picked up pretty soon. This is 250, right, Ms. Davis? Okay. Man, tell me your name.
Laurie Logan.
All right, Ms. Loban, you are here in an out-of-county warrant from Polk County. The judge signed the warrant set your bond at $250. You can post that bond, or you'll be transported to Polk County as soon as they come pick you up. All right, have a great day, man. I'll appoint the public defender to represent you. Have a great day, man. All right, ma'am, tell me your name.
Alisa McLennan.
Ms. McLennan, you are here in an out-of-county warrant from, somewhere as well. No, from Polk County. You're here for an out-of-county warrant from Polk County. The judge signing your warrant, your out-of-county warrant set your bond at none. The bond will remain at none until you get to Polk County. I'm going to appoint the public defender to represent you in this case.
Yes, sir. But is there any
So
way
Polk County's
that,
about to pick you up
is there
pretty
any
soon.
way that you can do a bond?
No, ma'am.
And how long will it be before they come and get me?
I'm not sure. I know Seminole County was here the other day. I know Polk County said they were on the way last time I spoke with them.
Yes, sir. And what if they don't? Like, can I come back to court and?
Yep, we'll get you back to court. And that's why I appointed a public defender to represent you. So call them, let them know that you've been sitting here for weeks or months, and we'll try to get you on to where you got to go. All right?
Yes, sir.
Have a great day. All right. Say your name, sir.
Anthony Ocasio.
Mr. Ocasio, you are here in an out-of-county warrant from Seminole County. The judge signing your warrant set your bond at $1,000. You can post that bond, or Seminole County is about to pick you up in the next few days or weeks, all right?
Okay.
I'll appoint a public defender to represent you in this case.
So I'll be able to bond out from here? Yeah.
You should be able to bond out from here.
Thank you.
You can. That's an old judge, right? Huh? Yeah, man, throw them out. All right, we got arraignments. All right, ma'am, tell me your name. All right, well, okay. On to our arraignment docket here. I have Elovito. Nicholas Elovito.
He's medical, Your Honor.
All right. Public Defender's Office Reyes is appointed to represent him. You all want to waive his arraignment?
We'll waive, Your Honor.
All right.
Enter a plea of not guilty.
I believe it's a VOP, right?
No, it's just a regular. Oh, yeah, there's a VOP.
No, it's the VOP, so we're in denial.
Yes,
Yes, Your Honor.
All right, I'll accept your denial. What dates do you have?
Division 62, VOP status, February 15th at 9:30, courtroom 9B.
All right. Then I have Bucci, right?
Butchie, yes.
All right. Ms. Bucci, you are represented by the Public Defender's Office. You've been charged in a 2-count information with trespass on occupied structure and resisting officer without violence. Both of those are first-degree misdemeanors, punishable by 1 year in the county jail and a $1,000 fine each. You have an offer to resolve her case?
Yes, adjudication of guilt, 6 months of probation, mental health evaluation, and any recommended treatment. Cost of investigation of $81.03 to the Orlando Police Department.
Can I go and speak to the client, Your Honor?
Does she have an extensive history?
I'm sorry.
State, does she have like an extensive history?
I believe that speaking to the officer and the, where the trespass occurred, that was the offer to be completed.
Okay.
Yes, go on.
Have a moment, Your Honor, I'm sorry.
There's mental health and what was the other condition?
I'm sorry?
There's mental health evaluation and treatment, and what else?
Just cost of investigation of $81.03 to the Orlando Police Department. And it was 6 months of probation.
Somebody thought about referring her to mental health court?
I'm sorry?
Somebody thought about referring her to mental health court?
I don't know, Your Honor, what the downtown ASA plan was. That was the offer that they had.
And Your Honor, you're not able to modify the bonds, am I correct?
For this case?
Yeah,
You need the information.
it would, because we're going to plead not guilty.
No, this, I mean, I can modify her bond, that's not a...
Yeah, I would,
My question was, does anybody thought about screening her for mental health court? Because
well, that's what,
she seems to be a prime candidate for that.
that's what we're going to try to, that's what I'm going to put the notes in the stack to do downtown, for the attorney downtown. So I would ask, we're going to enter a plea of not guilty, and I would ask that you release on mental health, pretrial release if she qualifies.
All right, Ms. Bush, do you have a place to go, place to live?
Yeah, I can call my mother or my husband.
All right, where do you live? Is the question.
I was staying with my mother. She lives in Christmas. She lives at 24606 Comet Street in Christmas 32709.
And do you have a cell phone on your property or a phone?
She does, yes.
All right. I'm appointed public defender to represent you. I'm going to release you on your own recognizance. I'm going to make a condition of her release on her recognizance that you keep in contact with your attorney, that you at least call them twice a month to keep in contact, and you don't miss any of your court dates, you understand? Your next court dates will be held on
Division 80 pretrial conference, February 19th at 9 o'clock, courtroom 9C.
Will that be given to me on paper? So that, okay.
Yeah, that'll be on your paperwork. And like I said, public defenders always represent you, so stay in contact with your attorney. If you speak to your next attorney and they don't know anything about mental health court, tell them they had to find out, okay? All right, have a great day.
Thank you.
All right. Good morning, sir. Tell me, well, good afternoon now. Tell me your name, sir.
You changed your bond.
Marshall Lamar Jackson.
So you know.
All right, Mr. Jackson, you are here in 2020 MM 9124 AO on a charge of trespass on property after warning. That's a first degree misdemeanor punished by 1 year in the county jail and a $1,000 fine.
He's not being held on this case. He was actually ROR'd on 120. So he's in jail on something else. So that's why this is still.
No, okay.
Okay.
The offer is adjudication of guilt, credit for time served, no return.
All right. Mr. Thompson or Ms. George, you want to talk to Mr. Jackson about that? That was close. Y'all throw a little Arraignments in there.
No. You still got 33 days. We'll be done by one. I think some of these are, they're not coming.
Well, we could do it all at the same time. Ms. Swanson? Let's start talking about some third degree motions while they're talking to Mr. Jackson. Brown 2020 CF 14310 AO.
That was the 310 Brown case?
Yeah, 310.
Granted, the state filed notice of non-filing before 33rd day.
Your Honor, can I briefly check with pretrial services? He's not in on this charge, am I correct?
No, he was RR'd on the charge.
Yeah. Defense enter a plea of not guilty.
Okay, so he's seen held on something else, right?
Yeah, he's been held at no bond on 2 other charges.
What are those charges? Those misdemeanor charges? Like, what?
Yeah, they're misdemeanor trespassing and a misdemeanor possession of drug paraphernalia, but he has no bonds on them.
Are they charged?
What's the case, Jason, give me a case number.
20 MM 8191.
There, is this a notice to appear?
Why is he in on notice up here?
I can't. Oh, we've not made a charging decision. His release was revoked when he picked up another case on that one. So we've not made a charging decision on that one. And what's the other case number, Chase?
That's it.
Oh, then, yeah, that's why. It was revoked. It must have been at IA's. I have the information is ready to be filed, but it has not been filed as of yet.
This is pretrial. For this case.
Division 84, pretrial conference, February 15th at 10 o'clock, courtroom 4B.
All right, Mr. Thompson, I'm going to accept your plea of not guilty in this case. Mr. Jackson's case, you'll be in front of the, hopefully all his cases be filed on the 15th of February.
Yeah, Your Honor, and our reasoning is, since it's gonna be handled downtown anyway, we might as well do everything down there.
Yeah, that's fine. We'll make sure that they all get the cases done at once, not pass the buck. All right, Mr. Jackson, your next court date is on February 15th. Have a great day, sir.
William Larson, Your Honor, is medical.
All right. It's 2021 MM 338 AO. Going to appoint the public defender to represent Mr. Larson. Do you all want to waive his appearance?
We'll waive, Your Honor, and enter a plea of not guilty.
All right. It says his plea of not guilty. You're going to settle for
Division 50, pretrial conference, February 8th at 2 o'clock, courtroom 7C.
All right, this is Liggins.
Higgins.
Liggins. All right, Mr. Liggins, tell me your name.
Tykeem Shamik Liggins.
All right, Mr. Liggins, you are here in 2020 MM 893580 on a charge of battery as a first degree misdemeanor punishable by 1 year in the county jail and a $1,000 fine. Mr. Thompson, what do you want to do? Is there an offer? One.
There's no offer, Your Honor.
Mr. Thompson, Ms. George.
Will enter a plea of not guilty.
I accept your plea of not guilty at this time, sir. We'll set you for your next dates are.
Division 63, pretrial conference, February 18th at 1 p.m., courtroom 12C.
Hold on, so, what was?
What's the next again?
February 18th at.
February 18th for?
Their pretrial conference.
Pretrial conference?
Represented by the public defender's office. These are my public defenders, but you have a set of public defenders in your courtroom.
Well, I want to represent myself.
You want to represent yourself?
Yeah.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give in this matter, the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Your Honor, at this time, he was already represented by us. We entered the plea of not guilty. We entered the plea of not guilty. So if he wants to represent himself, I believe you have to have a
Well, I got to hold the Feretta hearing first.
Downtown in the trial division, but not here, Your Honor.
Well, he's not entitled to keep your residence. I was going to withdraw you if he answers all the questions. I mean, it's your choice, because I'm going to go over all the problems with representing yourself.
Yeah, because the thing about it is, whether he represents himself or not, it's not going to change the outcome of this hearing, because there's no bond, there's no offer, so it's just not guilty. You take it to the next court hearing.
It does change the amount of the work that goes in between the hearings. So between now and your pretrial hearing, hopefully there's communication with the state of Florida. You all have come up with an offer. They've spoken with the victim. All that work of discovery's been done. And if he doesn't want that done by you,
he's not going to be able to do any of that stuff while he's in the Orange County jail. It's not going to be in this.
That's why I want to go over with him, Mr. Thompson. So I may keep you on the case based on how the Feretta hearing goes.
I think the public defender's office would like more time to speak to him before the Feretta hearing truly proceeds, so he understands in a more private setting what that risk is.
I've represented myself before.
So that's one of the questions. All right. Tell me your name one more time, sir.
Tykeem Shamik Liggins.
All right, Mr. Liggins, you are here this morning at Arraignment. The Florida Supreme Court, because of the emergency that we're having in our state and in our nation, ordered me to appoint a public defender to represent everybody that's in the Orange County Jail. Do you understand that?
Yeah.
Everybody's in custody is entitled to get a public defender.
Right.
All right. So you understand that you're entitled to court-appointed counsel at this time.
Yeah. Again, I would not like a court-appointed counsel.
I know. We got to go through this exercise to make sure that you're first competent to represent yourself.
Yes, sir.
And two, understand all the dangers that come along, the disadvantages and advantages that may come along with representing yourself. You understand
Yes, sir. As again, I have represented myself before.
I know. That's one of the questions I'm going to ask you in a minute, but I just want to get through this first part about your rights that you're entitled to. So you're entitled to representation. Do you understand that?
Yes.
All right. What was the highest grade in education that you received?
I've completed high school and I do have some college education.
All right. You said you've represented yourself. When was that?
This was about I can't remember the exact year, but it was driving with a suspended license.
All right. And do you understand that the charge you're facing right now, if found guilty, and you enter a withhold or you get a withhold or adjudication, then later on that charge can be used to enhance your sentence to a felony if you are alleged to commit the same offense again.
Yeah, but I'm
not saying you're guilty or not. I just want to make sure you're aware of that. That's a problem with your case. All right.
Okay. Yeah, but I know that I'm not guilty. So.
Okay. Now, the problem with representing yourself, especially when you're incarcerated with the Orange County Jail, is that you have limited access to this nice lady over sitting to my right, Ms. Swanson, who represents the Office of the State Attorney.
Right.
You can't call them. You can't send communications. All your communications with them need to be in open court. Do you understand that?
Right.
So that's gonna limit your ability to do any investigation on your case. You understand that?
Okay, well, I know all the details of the case, so.
You gotta answer my questions. So
Okay.
Don't give her any more information.
Yeah.
Help yourself.
Right.
And help Mr. Thompson if he's gonna continue to be your attorney by just answering the questions I'm asking.
Okay, okay.
All right?
Yes, sir.
All right, so you are experienced with all these. This is 2022 edition of our Florida laws and rules of evidence and criminal procedure. Are you
Right.
familiar with those rules?
I am familiar with my rights as a citizen and the grounds upon the case that the battery case, because I had battery charges before that have been dismissed.
Okay.
And
This is an exercise for me to make sure that you understand
Right.
that all the things that you need to be able to do when representing yourself. So do you understand that the judge presiding over your case when you get downtown is not going to take any special privileges just because you decide to represent yourself?
yes, I understand that.
You understand that that judge is going to hold you and other attorneys into that courtroom at the same standard.
Yes.
All right, they're not going to be able to aid you in what evidence is admissible or what procedures you should take in making sure that you protect your innocence. You understand that?
Yes.
All right. And you read. I'm guessing because you say you graduated from high school and you did some college, that you read and understand the English language.
Yes.
All right. Ms. Swanson, do you think there's any more colloquy I need to have with Mr. Liggins?
No.
Mr. Thompson.
Your Honor, I have notes in my, on his file in my office, and we may have competency concerns.
You may have competency concerns about Mr. Liggins?
Yes.
All right. Based on that reasons and that reasons alone, I want to keep the public defender on the signs of your case. But I want to note that the court did hold a further hearing today, and that based on Mr. Liggins' responses to me, he seems to be competent to proceed, but there may be some other underlying things that are going on. He did answer all my questions in a clear and articulable way, and he was confident in knowing that he wanted to represent himself at this time. So, Ms. Liggins, you may want to, when you get downtown, you still feel like you want to represent yourself, and some of those concerns have been lifted. The judge may allow you to represent yourself, but if there's a question, like I said, first thing, are you confident to represent yourself and whether you understand all the rights? If there's a question raised by somebody in the courtroom as to your competency to be able to do that, I have to take that into consideration. And the court tells me I can't appoint an attorney. I can't let you represent yourself if you're not competent to proceed. So once the court, you may want to ask the judge to look into that when you get downtown, and we'll get you on to your next court date, all right?
Okay, and my next court date is when exactly?
February 18th.
February 18th at 1 p.m., courtroom 12C.
All right, so when I get downtown, I have to restate that I want to represent myself.
I'm going to put it part of the court file that I already held a FREDA hearing with you and my findings of that FREDA hearing.
Right.
But that judge may want you to may see a doctor to make sure you're competent to proceed. I think you're competent to proceed. I think that you are articulable in what you want to get done. But if somebody else in the courtroom and on all sides raises that concern, then the judge needs to take certain actions.
Okay,
right?
Again, I know all the details about the situation.
Yeah,
and so.
I don't know, because hopefully you were there. And then that way you can help assist yourself in your counsel. But right now, I want you to keep working with the public defender's office until that happens, all right?
Okay, I mean, like, if I can request, I would would rather just be my own counsel from this point on the case, and if not, I understand. I'll ask the judge downtown.
Yeah, ask the judge downtown. Tell him that I found that you were competent, and I thought that you understood all your rights.
Okay.
But there was a competency concern raised by the public defender's office.
Okay.
And that judge may take some action, or they may not. But I want to put that on another judge without them having their own determination about what that means. Okay.
Right. All right.
All right. So have a great day, sir.
Thank you. You too.
Ms. Swanson, what about Mr. Derek Brown's other case, 803? trying to do two things at one time here.
Yeah, I'm doing other things. That should be denied. They were walking information over this morning, so can I have 1 second just to make sure I see it? 13803. That's the 13803 case.
It should have a e-file, right? $803, yeah, 13803.
Yes, Your Honor, it was filed this morning. So that should be
So
denied.
we'll deny that one. All right, tell me your name, ma'am.
Patricia Owens.
Ms. Owens, you are here in 2020 MM9094AO on a charge of resisting officer without violence. That's a first degree misdemeanor. I apologize. Punishable by 1 year in the county jail and a $1,000 fine. You're represented by the public defender's office. You all want to enter a plea? Is there an offer for Ms. Owens?
Adjudication of guilt, credit for time served.
Tell them all, Your Honor. You want to accept the plea offer? You want to accept the plea? Yes, we'll accept the state's offer, enter a plea of no contest.
All right. All right, Ms. Owens, could you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
Yes.
You put your hand down. Tell me your name one more time.
Patricia Ann Owens.
All right, Ms. Owens, you're here in 2020 MM9094AO on a charge of resisting officer without violence. That's a first degree misdemeanor, punishable by 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes.
According to your attorney, you want to enter a plea of no contest. Is that correct?
Yes.
You understand by entering a plea of no contest, you give the right to have a trial.
Yes.
You understand you give the right to have an attorney appointed to represent you at a trial.
Yes.
At a trial, an attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. You understand that?
Yes.
If there was a witness that did not want to come to court, the court can use a subpoena power to make that witness appear. Do you understand?
Yes.
You understand by entering this plea, you're given the right to appeal any errors that went along with this case.
Yes.
Are you under the influence of any drugs or alcohol at this time?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yeah.
What was that mental health illness?
Depression.
Do you take medication for your depression?
Dolo.
Are you suffering from any of the symptoms of your medication?
No, sir.
I'm sorry, for your depression, I apologize.
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
You all stipulate to a factual basis?
Yes, Your Honor.
All right. Based on
Yes, Your
stipulation
Honor.
of the parties, the court is going to find a factual basis for the entry of your plea. I'll accept your plea of no contest. I'm going to adjudicate you guilty of the charge. I'm going to give you credit for the 29 days that you spent in Orange County Jail with 29 days credit time served. The
Yes,
court costs and cost of prosecution in the case are $273. There's a $50 public defender application fee and $50 public defender lien for a total of $373. Ma'am, do you work when you're not with us? Do you have a job when you're not with us?
No, sir.
What do you do for a living? How do you survive?
I have a husband, my husband.
All right. I'm going to order you to pay all these costs directly to the clerk within 1 year of today's date. You understand?
Yes, sir.
All right. Have a great day, man. You got 30 days to appeal your judgment and sentence.
Thank you.
All right, sir. Tell me your name.
Keith Scott.
Mr. Scott, you're here in 2020 MM9088AO on a charge of resisting officer without violence. That's a first degree misdemeanor. It's punishable by 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, sir.
You're represented by the public defender's office, and State, do you have an offer for Mr. Scott?
Adjudication of guilt, credit for time served, cost of investigation of $166.11 to the Orlando Police Department.
Mr. George or Ms. Thompson, you want to talk about to Mr. Scott about accepting that offer?
He already discussed it with the attorney downtown, Your Honor. He wants to accept the offer and enter a plea of no contest.
All right, Mr. Scott, can you raise your right hand and be sworn in?
Before I do, can I ask, what I would say, can I ask you a
Well,
question?
talk to her.
What was the cost of investigation?
166.11.
Thank you. You can proceed, Your Honor.
All right. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Put your hand down, sir. Tell me your name one more time.
Keith Fitzgerald Scott.
Sir, you're here in 2020 MM 9088AO on a charge of resisting an officer without violence. That's a first degree misdemeanor punishable by 1 year in the county jail and a $1,000 fine. You understand that?
Yes, sir.
It's my understanding from the representation of your attorney that you want to plead no contest. Is that correct?
Yes, sir.
You understand by entering a plea of no contest, you give up the right to have a trial.
Yes, sir.
You understand you give up the right to have an attorney to represent you at a trial.
Yes, sir.
At a trial, an attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. You understand that?
Yes, sir, I do.
If there was a witness you wanted to call that did not want to appear, the court can use subpoena power to make that witness appear. Do you understand?
Yes, sir.
Are you under the influence of any drugs or alcohol at this time?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yes, sir, I have.
What was that mental health illness?
It was just bipolar and schizophrenic.
Are you suffering, are you taking any medications for your bipolar and schizophrenia?
I am, sir.
Are you suffering from any of the symptoms of your bipolar or schizophrenia?
No, sir.
Are any of those medications inhibiting your ability to understand the world around you right now?
No, sir.
You understand by entering this plea, you're giving up the right to appeal any errors in this case.
Yes, sir.
Right. And you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
All right, do the parties stipulate on a factual basis?
Yes, Your Honor.
We'll stipulate, Your Honor.
On that stipulation, the court will find a factual basis for the entering of your plea. I'll accept your plea of no contest. I'll adjudicate you guilty of the charge. I'll give you credit for the 29 days that you spent in the Orange County Jail. I'll impose cost of investigation of $166.11 to the Orlando Police Department. The court cost of prosecution amount of $273. There's a $50 public defender application fee, a $50 public defender lien. I don't have my calculator out, so it's not going to give me a total.
Oh, I'm sorry. Give me a second.
373 plus
I got $489.11.
$489.11. I'll give you 1 year from today's date to pay that cost of record to the clerk in full. Do you understand that?
Yes, sir.
You have 30 days from today's date to appeal your judgment sentence in writing. Do you understand?
Yes, sir.
All right, have a great day, sir.
Yeah.
All right, Travis Bell is my next 33-day motion, 2020 MM 8985AO.
That should be granted. The state filed notice of non-filing before the 33rd day.
I'm sorry. Which case was that?
It was Bell, Travis Bell.
Thank you.
I have Payne, 2020 CF 14879.
That should be granted. The state filed notice of non-filing